Delivery of judgment as in party.
In view of the reasons stated above, we are of the view that the prosecution has not been able to prove the guilt of the appellant in killing the deceased beyond all reasonable doubt. The appellant is accordingly acquitted.
Deeply obliged.
I have one unlisted item which I filed yesterday. The matter pertains to an appeal filed before the DRAT Kolkata and against the order passed by the DRT Guwahati. That matter pertains to condonation of delay. And now they are treating it as a regular appeal and they are asking me to deposit half the that amount, that is around 1 crore. And that is illegal. And I want that matter to be heard on Monday, 8th of. Yes, kindly accommodate me. I come from Manipur.
It can be
It is only in a considerate thing they are going for the same rigor would be.
Monday.
Obliged, sir.
May please. My lord, items 7 and 9. In these two cases, my lord, I am for the appellant.
7, 8, 9.
7 and 9, my lord. 8 is, my lord, by.
That is connected with 6 also.
Yes, my lord, in fact.
7, 8, 9.
Yes, my lord. For 8, my lord, my learned senior friend is appearing.
Yes.
And in 6 is, my lord, she. For some, I'm asking for some accommodation today, my lord. I have informed the respondent, my lord, Mr. B. Sinha is also there, my lord.
Yes, any problem? On the prayer for adjournment made by Mr. S.K. Talukdar, learned counsel for the petitioner,
Appellant, my lord.
appellant,
Yes.
WA 12025 and 1141/2025, which is not objected to. In all these it is not objected to the answers for the other side. This is the matter when
After vacation, man.
after vacation.
May I pay, lots of.
Yes.
Item number 29 of today's list. An adjournment slip has been circulated yesterday. Lordship.
Yes.
In this matter, learned AG is appearing for respond number 2 and 3. Today, he has some personal difficulty. So can it be posted on Monday?
Everything Monday, so we'll have a problem.
So I appear for the respondent four in this matter.
Who is for the petitioner?
Lordship, we are for the petitioners, your lordship. Lordship, the matter may also be taken up after vacation. They are still enjoying status quo in this matter, your lordship.
We are suffering
Who
the
is-
status quo. They are enjoying this.
They are
They are enjoying.
Lordship,
listed.
Setting up.
After vacation, there is an IA for state.
They have a license. Clearance given. Okay? Then it was downloaded. Then there was a direction to you, this was a vending desk. Now they revived the old one. And that is what is.
Okay, so.
Monday.
after vacation, your lordship.
Wednesday. When, huh? Thursday?
Lordship,
Well, no, Thursday is hearing day. Wednesday. Wednesday.
lordship, if I may, my senior may not be available on that day, your lordship. So, lordship, on the 16th, your lordship.
So
16th, your lordship.
Huh?
no,
The last week before vacation.
Last week.
no, Lordship, before Lordship sets a date, can we just discuss among ourselves and give a date to the benches?
Okay. Right, on the prayer made on behalf of the learned AG Assam, list the matter on, give a date.
Yes.
Lordship, interim may be continued.
Interim order to continue till the next date. When, give a date.
Yes.
May it please your lordship. The
Lordship.
consent of the other side,
Lordship,
lordship.
as I have been. 18, I have been suggested with 18.
18.
Yes.
Lordship, with regard to item number 15 and 16, we have circulated a adjournment slip yesterday, Lordship, and I have taken consent from the other side. So may I pray this matter may be adjourned for 2 weeks, Lordship?
and 17.
15, 16, 17.
Yes, Lordship.
Who is for 17?
$17.
Who is for the petitioner? You.
Yes.
Correct. On the prayer for adjournment made on behalf of the petitioner's counsel, which has not been objected to by the other side. This is the matter
After vacation, Lordship.
after vacation.
Obliged, Lordship.
May I plead the lordship, my lord, I beg to mention item number 18, my lord. That contempt may be closed, my lord. Contempt petition.
Why?
My lord, in fact, order has been almost complied with. Only a some portion, the EPF has been deducted from the area bequeathed, that has not been paid, but rest has been paid to the.
For the petitioner.
I am for the petitioner, my
Oh,
lord.
yeah, but
Yes, my lord.
you are standing this side, so by habit.
Yes.
You are more comfortable that way, huh? Okay, right. Mr. DP Bora, learned counsel for the petitioner submits that he does not wish to press this contempt petition any further in view of the fact that there has been substantial compliance with the order. Uh, in view of the submission made by Mr. DP Bora, the contempt petition stands those as not pressed.
Deeply obliged.
May it please your lordship, I beg to mention item number 6. Kindly adjourn for the day
Already adjourned, okay.
on this.
May I please, Lordship, prepare for listing a writ petition, Lordship. It's a surfacey matter, Lordship. Section 14 is there, Lordship. What happened, Lordship? We have purchased a property through auction, Lordship. Thereafter, sale certificate also issued, but we are not getting the position. That's why.
Writ petition?
Yeah, before it was listed before single bench earlier.
Ah.
Thereafter, landed single just direct to list it.
Why should it go?
Surface matters are before the division.
That is not a surfacey matter in a way.
No. That is not.
That is not a surfacey matter. It was a single judge has directed that. It's not a surfacey matter. It's a basically non.
14 of surface
There-
area is there. That's why landed single.
That is all finished now. Basically, auction has been done. Only you have not been given possession of the property
Yes, Lord.
by the bank due to whatever reason. Anyway, what to do?
Or we'll have to get it.
When?
Next week, Lordship.
Your Friday?
Obliged.
Also, with regard to item number 11, your lordship, the counsel assisting the senior advocate lordship, he has suffered a emergency in the family, your lordship, an emergency family lordship. May I plead the matter be taken after a week, your lordship?
Lordship, I'm for the appellant, lordship.
Who has brought the records? It is here. We'll see. We'll see.
Can it be on Monday then?
Huh?
Monday.
No, we'll see. We'll see.
Only a small point.
There's a small point. We'll just see that.
Lordship.
Who is Mr. M.K. Chaudhary?
No, lordship, I'm for the respondent, your lordship.
Lordship, I'm for the appellant.
The Parthomedy who is assisting me,
Uh-huh.
his uncle has suffered a heart attack, so he's in.
See, because a small point. We'll just see.
No, but there are other aspects are also there. We have also, actually, we're supposed to give a citation of what is Millard peer review, what is their care review, everything, those aspects.
No, we will just see that. Yeah, there are just see, since they brought the record.
May I please, your lordship, with the consent of the other party, I beg to mention item 5 of today's daily lordship.
At 5.
Lordship, we have also circulated the adjournment slip yesterday.
You're not. You plan. Honestly, making this in the, no, it's not, it is not even there in this, but they have not. Then we just said,
You're for the petitioner.
No, Lordship.
You want to adjourn the matter. Why?
Lordship, the engaged counsel is in personal literally today.
Who is the engaged counsel?
And thus, no.
Yeah? Imdas.
It's a case for.
I know. Huh? Okay, right. On the paper adjournment made on behalf of Mr. M. Das, Senate Counsel for the appellant. Please the matter after vacation.
Earlier, please.
May I please, Your Lordship, I beg to mention for listing of a rate appeal, my lord, which was filed on 29/11, my lord, for Monday, my lord. My lord, Honorable Single Judge has rejected our prayer for constructive res judicata, my lord. It's regarding the headmaster promotion, my lord.
You will take.
15 to 3.
Okay.
My lord, oblige me.
15 is okay.
Better?
Your Lordship,
Division bench has already passed. The covered judgment.
Your Lordship, I've given the judgment.
Yes.
No, why is the repeal being filed? You could have gone before the learned single judge.
No,
It's really.
no, Your Lordship. This was a case, it's not a writ appeal, Your Lordship, it's a writ petition challenging the rules.
They're challenging the.
Why are you challenging the rules now?
Your Lordship-
Rules challenge is gone.
No, we have not been a party to those proceedings, Your
Now,
Lordship.
now your case is you're a tutor, you want the salary, pay scale.
Yes, Your Lordship. Now the issue,
But you've been allowed, I suppose.
no, Your Lordship, the issue is like this. The petitioners have made a challenge before the Honorable Supreme Court against that judgment. And the state has filed a review before the Honorable Division Bench, Your Lordship. So we want to join that wagon, Your Lordship. That's the only.
That is the law.
What is the case that is pending? Here, the review petition?
It's a review petition, my lord.
What is the review petition case number?
Yes, sir.
It states
15/25. I have given a copy of the order. 15/25, my lord.
I've given this judgment.
Pending, my lord.
So let this be listed along with that review petition.
No, Your Lordship can dispose of it. Whatever will be the outcome, I'll face it, Your Lordship. Keeping it pending doesn't make any. Because appeal has also been filed against those judgment before, Your Lordship. I'll just place those appeals, Your Lordship.
Yeah.
we can only say that this will be covered by the. Only covered by this.
And the appeal was prior to this.
Heard Mr. R. Singha, learned counsel for the petition. Also heard Mr. N.J. Karunia, learned appearing for the.
Education.
For the standing counsel.
Department
School
of School
Education Department appearing for the respondent. Appearing for the respondents number
1, 3, 4, and 135.
135.
135, my lord.
My respected senior will appear for 6.
Also heard
Yeah.
Mr. A. Chalia, learned standing counsel Finance Department appearing for the respondent number 2. So Ms. B. Bhuya, learned senior counsel appears for the learned senior counsel, standing also standing counsel BTC, it's for the respondent number 6. So the petitioner, by way of instituting the present petition, has presented a challenge. The provisions of section 2U, 4, 2, bracket 4, Roman 6 7 and 24 of the Assam Education provincialization of services of teachers and reorganization of educational institutions Act 2017. Page 52 does it sign. Also, the Learned Council, Mr. N.J. Khatmiya, Learned Council for the Learned Standing Council, Department of Security, has submitted a similar challenge presented to the provisions of the Act of 2017 was considered by a coordinate bench of this court in the case of Mohor Ali Sheikh and others versus State of Assam and another, reported in 2024 bracketed 5 GLT 689. Also, it submits that on a consideration of the issues arising in the said proceeding, the coordinate bench had rejected the challenge so presented to the provisions of the Act of 2017. Also, he submits the case of the appellants, our writ petitioners in the present writ petition would be covered by the decision of the coordinate bench in the case of Mohor Ali Sheikh and others. Also, Mr. S. Sinha, Learned Counsel for petitioner. R. Singha, Learned Counsel for the petitioners, submits that the case of the petitioners would be covered by the decision of the coordinate bench of this court in the case of Mohor Ali Sheikh and others. Also, in view of the consensus arrived at by the Learned Counsel for the parties to the proceeding, we are of the considered view that no further adjudication would be called for in the present writ petition, and the same can be disposed of in the manner by applying the decision of the coordinate bench of this court in Mohor Ali Sheikh and others. Also, accordingly, the present writ petition stands disposed of in line with the decision of the the coordinate bench of this court in the case of Mohor Ali Sheikh and others. Supra. Anything more?
Deeply obliged, Your Lordship. Obliged.
My note is there.
May I please, Your Lordship?
Yes.
In this petition, Your Lordship, we are praying for issuance of necessary direction to respondent number 123, whereby we have filed in section 14 application before the respondent authority for taking the possession under the SARFAESI Act. But since 2022, it is being pending, Your Lordship.
Have you clarified the pata type of the land?
Yes, Your Lordship, that has been clarified, Your Lordship.
What type is it?
It is T pata, Your Lordship.
T pata. Okay.
Yes, Your Lordship.
So, yes, Ms. Sharma.
Humbly draw your lordship's attention to section 14 of the Act. Let the bank file an affidavit stating that they have complied with the proviso to section 14 subsection 1, which is mandatory, as has been. I don't have the decision right away, but the Honorable Supreme Court has said that it is mandatory. Subsection 14(1), the proviso thereto, the first proviso. Provided that any application by the secured creditor shall be accompanied by an affidavit duly affirmed by the authorized officer of the secured creditor, declaring that, Malad, all this. Have they done that, Malad? If they have done that, let them come and file an affidavit. And then we will respond. It cannot be just...
My application, they have acted, Your Lordship.
Maybe.
But they have never come out with any defects that whether there is any defects in the petition. And since 2022, the continuous correspondence is with them.
This was never an issue taken up by you earlier.
But Malad, the Act, it stands,
Maybe Act may say something.
Honorable Supreme Court has said it is mandatory, my lord.
No, maybe,
Yes,
but
yes.
that is not an issue taken up. It's maybe an issue taken up by you, but not by your clients.
Legally, my lord, that's what it is. If they have not done that, my lord,
See, that can be done. That is not an issue. That is not the reason that they have kept stalling this issue.
they will obtain instructions.
When you obtain
They
instruction-
the bank should also, it cannot be just brawn, my lord.
No, but you could have told them that in 2022.
Yes,
Why-
Your Lordship.
Wait now, you see, earlier, your only issue was that there was a
Look it up, my lord, with my.
clarification with regard to the.
I will seek, my lord, but
Yes.
that should also be forthcoming.
That would be forthcoming. You should have told them then.
I will obtain, my lord.
You cannot just keep quiet and just do nothing about it. Obtain instructions, right? Heard, Mr.
Sir, Your Lordship,
Senate Counsel for the petitioner bank
India.
submit that despite communications, despite letters being issued under Section 14 of the SARFAESI Act 2002, the state respondents have not taken possession of the secured asset till date. He also submits that the clarification required by the respondents with regard to the type of pata of the secured asset has been clarified in as much as the bank has stated that the secured asset is a T periodic pata. TEA, T periodic pata. What's up? Ms. S. Sharma, the learned counsel for all the respondents.
Respondents 2 and 3
Respondents 2 and 3.
and 4, my lord.
2, 3, and 4 submits that she will obtain instructions with regard to the above. And with regard to why possession of the secured asset has not been taken by the respondent. Full stop. He also submits that the petitioner has not submitted any affidavit as required under the proviso to Section 14(1) SARFAESI Act. The petitioner's counsel shall also obtain instructions with regard to the above. Who appears for the state for one? Ms. Bordoloi, N. Bordoloi appears for respondent number 1.
Obliged.
List the matter. When?
My lord, this is from
When do you want?
Dibrugarh, my lord, a week's time, subject to the convenience of this honorable court. Deeply obliged. My lord.
Obliged, Your Lordship.
Supplementary motion 31.
May it please your lordship.
Yes.
Your lordship, in the, this is a matter pertaining to SARFAESI Act. Here, there is no security interest against my property. I am not the borrower. I am not the guarantor. There is no secured interest against my property. Even thereafter, there is only one agreement for sale. This is not a sale deed executed. Based on this agreement for sale, possession notice has been issued. Your Lordship.
Is there any alternative remedy available?
Your lordship, alternative remedy would have been available if you would have the relevant documents from the bank, or if you had known what is the loan amount, what is the loan sanction. We are not made a party to it. We are a complete stranger to avail anything for an alternate remedy. Your lordship.
There is an agreement to sale.
Agreement only with the party. Then that party went and took a loan from the bank. We are not a party to it, Your Lordship.
No, maybe. You said there is an agreement to sell.
Agreement to sell, Your Lordship.
From you.
From you.
You to that loanee.
Loanee, Your Lordship. And then the loanee owns and takes a bid.
So can't that be made a mortgage?
Indeed, that is the moot question, Your Lordship. Page number 47 would clarify, Your Lordship.
Very good. Parties. Very good.
Page number 47 kindly, your lordship.
Decision of this.
Page number 47 would clarify my stance, your lordship. Details of the property mortgage, and in point number 1, last page it is written, and having agreement for sale only, your lordship. Based on that, they have
No, but
fixed their
then
position.
will this agreement for sell, agreement to sell
Whereas the agreement itself was not completed, partially done,
was not,
not completed. Partial payment was done, agreement falls, your lordship.
Agreement was there.
The contract it's not executed.
would it come under this section 2 ZF?
Indeed, your lordship, that is not secured interest. The bank has zero secured interest against us. That is the only problem, your
The
lordship.
difference between the Transfer of Property Act and the.
And this, indeed, your lordship.
Yeah,
Our claim is
here, any kind.
any kind, your lordship. Secured interest bank does not has on our property, your lordship, because we have not executed a sale deed, neither we made a party to the loan agreement. There is nothing which the bank can come to us, your lordship. The bank, and this is only an agreement for sale which is not executed in totality, your lordship. The agreement itself falls, your
There
lordship.
is a decision of the division bench of this.
I beg ignorance to that, your lordship.
Just missed out.
I beg ignorance to that.
You can just ask Mr. Dida, senior counsel,
Indeed.
or Mr. Costa Pata.
Okay.
Get that decision.
Okay.
I think that would be, I just forgot the case number. So can it be taken up after some time? That decision will be after some time. Just have,
In the meantime, I'll take this instruction.
just have, take it after. some
Indeed, deeply obliged.
time. What to take it up? I'm- business of the- It's-
Then you
it's-
found.
It would be better.
May I please, your lordship. The arguing counsel, Mr. Zorawar Singh, was supposed to reach Guwahati yesterday. However, multiple flights which were operated by Indigo were cancelled. So thus he is supposed to board a flight today at 11 o'clock or something. So thus the matter may be taken up at 2:30 or 3 o'clock.
Ah,
I humbly pray if I may be permitted on that as well. 3 o'clock.
Only thing is, Lord, I have no problem. But yesterday I faced the same ordeal. Eventually the flight was cancelled.
You're supposed to go.
And I came, but I had to I had to come by SpiceJet. I couldn't. My flight was in Indigo. It was cancelled.
It's very bad.
Not only here, everywhere it is happening.
Is it, why is it?
Actually, I understand the problem is on account of staff problem.
That is what.
Crew and staff.
No, that would.
No.
That is only.
No, but that technical part has been addressed.
Okay.
Therefore, yesterday itself, there was a news item in Times of India that has been addressed. Possibly, it is totally understaffed. Therefore, yesterday, Lordship will be surprised to learn we landed at 9:13. Up to 10:30, there was no ground staff. That's why we were stranded in the aircraft. That is the position. And if one has to take luggage, it will take another 2 hours.
With Indigo, never heard about that.
Never heard of. And these are the two airlines, Indigo and Air India. Others are. And I'm not, we can have it in the, but I have my doubt.
Anyway, let's try.
Yes, no problem.
2:30.
3 o'clock, 3 o'clock.
To be on the safe side. Milord,
We also,
Instructions are here.
no, it will be with him.
It will be coming with him.
It's with him.
instruction means they'll come with the records, I understand.
No, we had also asked one query to him, whether the screening committee also looks into the service records of the persons in the zone of concern.
Lordship, that instruction is also with him.
Milord, 2-3 aspects. We have again applied our mind. Since he'll be coming with the records. If your Lordship kindly permits me, I'll take 15 minutes time just to refresh your Lordship's Milord memory.
Yes.
Maybe you do it that time.
But I have my doubts, Milord, today whether he will reach.
Then what is the point? That is what. No, you're taking 15 minutes now. It doesn't turn up. And it's time wasted.
Okay, then Milord, before he produces the record, I'll take 15 minutes time to refresh two more things, Milord.
Deeply observed.
Lordship, this writ petition is filed by the Union of India challenging the order passed by the Land Tribunal, Lordship. There is a stay order of operation.
Yeah. What is
Other
this?
side has filed a
Mate. How do you pronounce it? Mate. Electrician.
Mate.
So basically, the issue is whether the peon can be promoted as a mate electrician.
Yes.
That is this simple point. Correct. Now, now the issue is basically whether you have a different line of promotion and whether this other person,
Safaiwalas and Chokidars, not peon, who were promoted.
whether the MTS peon has a separate line of promotion and whether this
This is service rule for peon, Lordship. If your Lordship look into the this 30 SRO 309, the schedule next page. The peon next post is Daftari promotion.
No, where? The rules of 2013.
No, Lordship. This SRO 1971, 309.
Okay, this
SR
one. The separate document. Okay, Daftari, yes.
the schedule next page. Name of the post Daftari. And Lordship will have bottom promotion peons with 3 years service in the grade.
Correct. So this is for promotion from
peon to Daftari. And so far as this, since 2013, it's 100%, Lordship, 80% direct recruitment, 20% by from deputation.
As per the rule.
As per the rule.
As per the rules, this is
In the schedule, that is third page. Second page, your Lordship will find mate at the top, schedule.
Yes, mate.
Mate. Next page, Lordship. Method of recruitment. 80% direct recruitment, 20% by deputation. So there is no scope for promotion since 2013.
Correct. So just because he has passed the trade test.
That's why he made the demand.
So that is his claim.
Upon that, at page 40, Lordship. That it's a letter of Lordship. The CAT has also relied on this letter, but it has been cherry picked.
Page 40.
Page 40.
Yes.
This is the memo which has been relied by the respondent. The second. Second law.
Yes.
It is however seen that certain employees, after being designated as maid, refuse to carry out the duties Safaiwala Chokidar peon on the plea that they have been promoted as maids and have caused to Safaiwala Chokidar peon. This is creating administrative problem, and it has been suggested that non-industrial employees should not be promoted to the industrial category. Now, maid is industrial category, and this peon Chokidar, they are non-industrial. So
in any event, whether this document could supersede the rule.
It's only a welfare measure.
The rules produced, but they make statements.
So you have not produced these rules before the single judge.
No, before the CAT.
Before the CAT.
Lordship.
Before the CAT, you have not produced.
Perhaps.
Actually, they'll make a mistake.
No, rule can be always look into, Lordship. Because we could have, Lordship, we could have preferred a review, but that is only limitation 30 days. There is a decision of this court. It can be condoned. And in fact, Lordship, now all are in the same grade pay.
No, it is there,
Eight
my lord. But thing is that, my lord, their contention is that, my lord, from 2013, there was no promotion from Chokidar to maid. If lordship may kindly come to page 118, my lord. It is a letter of.
Just a minute. Chokidar? What do you mean Chokidar? You're a peon.
Sorry, from peon to maid. Now lordship may kindly come to page 118, my lord.
118.
It is a letter in the year 2014, my lord. 17 January 2000.
118. No, one thing. Can a letter supersede or override a rule?
No, it is there. my lord.
Huh?
It cannot be.
Then
But it is there only.
no, maybe. But the law, what does the law say? Can it override?
And in fact, my lord, they have not produced the rules before the Larner Central Administrative Tribunal.
Yes, let us see 118.
My lord.
118.
118, my lord.
Yes.
Promotion of Chowkidar and Safaiwala.
You're not a Chokidar.
My lord,
You're not a Safaiwala.
but it is explanation is given like that, my lord. Chowkidar, Safaiwala, my lord, Chowkidar, Safaiwala are not the feeder category for promotion to maids.
So, but you're still not Chokidar or Safaiwala.
Yes, it is there.
This is only for Chokidar and Safaiwala.
They are also not feeder category of to maids, my lord.
You see, just because promotions have been made in violation of the rules for somebody, that does not mean that gives you a right to be promoted
Yes.
in the same illegal manner. Two wrongs don't make a right.
But it is,
Simple as that.
yes, my lord.
How
but-
can we, just because there has been an illegality committed or a wrong committed, can we say that because you have committed a wrong earlier, you continue to commit the wrong? Can we say that?
But they are also, my lord, not producing the relevant rules, my lord, before the Larner Central Administration.
Did they make yes, that is correct. That is one problem that they did. But
Yes.
it has, at the end, it has come out, no? At last, truth prevails. That type of thing. You know? What can we do? We have all the sympathy for you, but then the problem is that they should have produced it before the learned cat, but they did not do it. And
My lord? No. Yes. Sorry. Long stagnation, my lord. From 28 years, my lord. I am stagnating in the same.
MSCP, two MSCP has been given, first and second one given.
yes, he have been given MACP also. Last MACP 2018, I think.
18.
There's a second MACP.
Second is 2018.
And you retired when?
Is that-
Retired.
Not yet retired.
When are you going to retire?
That
You might get the third MACP also. How do you know? The 10 years usually.
Age is now 52 years.
52. He'll get his third.
Lordship.
Oh, he might get promoted to Daftri.
Lordship.
He's 100. Okay, basically, writ petition allowed, writ appeal allowed.
Writ petition.
Writ petition allowed, sorry, writ petition allowed.
Deeply obliged.
That is- We'll pass the order now, otherwise it'll be a problem later. Right. I heard Mr. B. Chakrabarti, learned counsel for the writ petitioner, and
Yes, sir.
S. Chowdhury for the respondent. The writ petitioner has paid for setting aside. Where is that order?
Okay, page 82.
For setting aside the order dated 9/6/23 passed by the Central Administrative Tribunal Guwahati Bench in OA number 040/00033/2018, by which the respondent, respondent, one slash writ petitioner's prayer.
No, Lordship, this is applicant.
I'm sorry, again, the respondent number one's prayer, respondent number one slash applicant's prayer for promotion to the post of maid electrician had been allowed. The learned tribunal had in the impugned order directed that the applicant was entitled to the benefit of promotion in terms of the office order dated 17/1/2014 issued by the Directorate General of Personnel slash CSCC, Engineer in Chief's Branch, Integrated Headquarter of MOD, Army, Kashmir House, New Delhi. Accordingly, the orders dated 29/3/2017 and 19/5/2017 were set aside. The petitioners were directed to hold a review DPC as per the circular dated 17/1/2014 and grant promotion to the respondent number one to the post of maid electrician with effect from the date when similarly placed employees were granted promotion who had passed the trade test for maid electrician bracket semi-skilled.
Semi-skilled, thereafter
Semi-skilled and electrician bracket skilled. Full stop. Next paragraph. The learned counsel for the petition submits that the peon has a distinct promotion line while the post of maid electrician can only be filled up by direct recruitment and deputation or re-employment of armed forces personnel at the ratio of 80% and 20% respectively in terms of the Military Engineer Services Industrial Group C tradesman maid slash bracket semi-skilled post recruitment rules 2013, hereinafter referred to as the 2013 rule, which came into effect from 8/7/2013. On the other hand, the promotion of peon would have to be to the post of daftari, DUFTRY, DAF or DUF? DAF.
Here.
DAF, TRY, in terms of the military engineer services bracket. What is this in bracket? Some industrial, before industrial, what is this? Non-dash industrial.
Class 3.
Class 3 and class 4 bracket close.
Recruitment rules.
Recruitment rule 1971, hereinafter referred to as the 1971. As such, when there are definite and separate rules for recruitment to the post of mate electrician, which does not include peon as a feeder post for the as a feeder post, comma. The learned tribunal erred in directing promotion of the respondent number 1 to the post of mate electrician. Next, we have heard for the party. The operative portion of the order dated 9/6/23 passed by Cap Guwahati bench in OA number 040/00033/2018 states as follows. Page 100. Take this up. Next para. The circular, no, the office order dated 17/1/2014, on the basis of which the promotion of the applicant, respondent number 1, was to be effected, is states as follows. Page 118. 118. Next. A perusal of a bare perusal of the office order dated 17/1/2018 clearly shows that the same pertains only to promotion of chowkidar and safaiwalas to mates. It does not speak the promotion of peon to mates. Stop. Next. The 1971 rules provides for promotion of peon having 3 years of service in the grade of peon to the post of duff. On the other hand, the 2013 rules provides for recruitment to the post of mates 80% by direct recruitment and 20% by deputation or re-employment of armed forces personnel, failing which by direct recruitment. As can be seen from the 2013 rules, there is no scope for promotion. Though the learned counsel for the respondent number 1 had taken a stand that chowkidars and safaiwalas had been promoted to the post of mates, we are of the view that the said promotion could not have been done in terms of the 2013 rule. Further, the office order dated 17/1/2014 cannot override the provisions of the 2013 rule. When did you pass the trade test anyway?
Yes, my lord. At page 30 and 31, Lord.
Next. I'll complete it later. Basically, the dismiss, we'll complete it later. I'll continue, huh?
DP.
Dismiss. Land acquisition in 1960 combination. What did it? Yes.
Yes, Lordship.
What is your case?
Case, Lordship, the government side acquired land, 13 bighas of land, in the year 60,
What law did they acquire the land?
under the Land Acquisition Act.
Under the land acquisition, what?
Land Acquisition Act, Lordship.
Which land acquisition act?
1894, maybe.
1894.
Maybe not.
Then what do you want now?
Lordship, at that time, the compensation amount was fixed at 5 lakhs for 4,000 rupees.
Correct.
Yes.
Okay, so
But
problem is. Yes.
But presently the amount is very less, Lordship. That's why
You see, Mr. Counsel, it's like this. First of all, the which year?
68, 69, Lordship.
68,
69.
1968, 69.
Yes, Lordship.
After 40 years, they have approved.
Now, where is your appeal? Now, your case is that you have not been paid the compensation amount.
No, Lordship, amount was given only,
For the crops or whatever.
yes, only. The amount is very less, Lordship.
Amount was given for what?
For land, Lordship.
Amount was given for land.
Land.
Now, if it was acquired under the 1894 Act, then if you're agreed with the awarded amount, you can always go under Section 18
Yes.
for reference.
Okay.
And you allow that part. And we how can we allow this petition? That where's the issue of reference and
Enhancement.
You have not received this order yet. You have not received this order at all. How did the you see the under the 1894 Act,
Yes, Lord.
the award that is to be pronounced is made under Section 11.
Yes.
If you are aggrieved with the awarded amount, there is a time limit, maximum 6 months.
Yes.
That you file a Section 18 reference petition.
Yes.
Now that reference petition will decide whether you are entitled to enhanced amount or not. That not being done, you have come to the court. When did you come, single bench?
We filed a petition in the year 2012, Lordship.
2012.
40
After
years.
how many years?
40.
Huh?
40 years.
After 40 years, you have
Yes.
come.
And petition was allowed.
And petition was allowed and giving you a specific amount.
Yes.
On what basis?
On the basis of Lordship.
That is not as per the rules. I mean, as per the act. Where are you? What are you doing? How can you go? First of all, I don't know, we have got some reservation on how the order has been passed. But how are we going to determine what is the actual amount you are supposed to get? What is the basis? What is the basis?
Then Lordship, liberty may be given to us to file. The
No,
petition
no.
for the enhancement.
You were supposed to file your reference in 1968,
Then
69. But the problem is, the single judge has given this order. After 50 years.
single judge has given the order based on some records. Yes. Some
And he has
records.
quantified an amount that is to be paid. I don't know on what basis. But you are keeping quiet, they are happy with it.
But in fact, to that matter, the deputy commissioner has produced records as relating the acquisition, whereby in those records, it has been reflected the amount which has been calculated, the 5 lakhs odd amount. So that amount has been said, and there is a statement to the effect that the amount has been received. but the person's signature or nothing was there.
Council, this is not your appeal.
Actually, this is appeal.
This is not your appeal. You cannot challenge what has been stated by the single bench.
Yes.
But we are telling you the problem being faced by us. Yeah, according to you, the judgment of the single bench
No.
is correct.
No.
Then, but you cannot say no when you have not filed an appeal.
That's true.
But how can we allow your appeal saying that you should be given a higher amount? On what basis? When we don't find the basis for the single judge coming to
Conclusion.
Yes. You want to withdraw, you withdraw.
So, Lordship, then Lordship, another date may be given. My senior will appear, Lordship.
He says 1960. And therefore, this petition is to be available.
Visit and also.
And available because of the LA case.
Exactly, we say it will not fix cost. If you want to happen with high up it will be super DDT. What the hell? ওটা actually দেখাবো না কেন গভর্নমেন্ট অফিসার দিব না কেন out there everybody is big now he appear by now
Okay, date may be fixed. My senior will happen.
Yeah.
AK Das, Lordship.
Where is he?
Today he's not.
Then why did he send you? Why did he send you? Today, what do you think we have done?
I thought, Lordship, I will.
It's not only, we have not come here to sit and show our face.
No, Lordship, I thought I try to satisfy you, but.
No, so we are not satisfied.
Yes,
Yeah.
I
We do not find any case.
I thought I will try to satisfy.
No, we do not find any case. You can go to Supreme Court.
A date may be fixed.
No. You should have said that in the beginning. Or you should have asked for time. You see, you're wasting our time. What do you think we do? We also want to sleep early.
Also, the solitium was not added. Interest was not.
Solatium not in.
Mm.
Now you see why did you go to the single judge? Because you were not paid compensation.
Yes, sir.
It is not a case that you should have been paid higher compensation. When you come to page 72, it says there that the amount had been paid. The records show that the amount had been paid, but to whom it was paid, it was not known. And that was in 1968-69. And you are lucky the single judge has said that amount should be paid to you now. Now, how can you challenge that?
Lordship, the register was produced before the court. And there was no signature, Lordship. The who received the amount.
Okay,
Yes.
okay. So you are lucky. But then now you cannot go beyond your prayer, no? Let us see your prayer. No. Oh, Solatium. That you cannot. Solatium and all cannot be. That you have to go for reference at that time. And what were you doing?
But we were not aware at that time, Lordship.
Huh?
At that time, the petitioner was not aware, Lordship. We filed in the case 2012, Lordship. So, and we filed RTI, and then we collect the records and all, Lordship.
Problem is that. Yeah, we feel careful now.
Are you contemplating to file this appeal this Sunday?
Lordship, in this matter, Lordship, the records were derived from the Deputy Commissioner's office. So in this regard, we need to discuss with the senior government advocate what needs to be done, Your Worship. Because yes, exactly, Your Worship.
That means you have accepted this outcome. Now pay everything.
Then you pay, what is that? The single, we cannot go beyond the single judge order, that's all. There's no question of payment of solatium and interest and all that this thing. We do not know. After 40 years, you file a writ petition.
Compensation will be paid by the promoter board. As per my knowledge, promoter board has already released the amount to the petitioner. No, after passing of the single judge order.
No. We have not received yet, Lordship, any amount.
After my
Promoter board,
and
And
appeared, he told me that. Stand, what?
presence of the person. Stop killing the name. Petitioner को contact करना है तो सर हम It was money.
In a recent judgment,
Huh?
in a recent judgment, I have placed on judgment lordship. In that judgment, Supreme Court held that since there is a delay, they are not entitled to Indian interest in partnership.
Mr. Counsel, you're not even,
It happened already condoned, Lordship, by the.
you're not even understanding the issue.
No. The requiring department is Lordship Promoter Board. Since he is not present, Lordship, may adjourn for the day, Lordship, I'll inform the fixed date, Lordship.
Please try to understand the case. Read it. Just read the judgment fully and see the problems that might arise in the future. You are not using you think about what might happen and what. I mean, and this is not. I mean, there's some things, but you have to pay. You pay the amount. Since you're not challenging it, you pay the amount. That's. We're not going to say anything beyond that. On the prayer of. How do you know? And that has been everything. How can you do that? And they're expecting all this. If this type of judgment is allowed, what will you call it? You see the, they're not understanding the. Right. The prayer of the counsel for the appellant and the respondent list the matter after review.
Your lordship.
Yes, see. Yes, flag it.
I have flag marked it. Whatever. Original. By the.
My lord, may I draw your lordship's attention to the last order passed by your lordship, my lord. There, my lord, there are two directions. At my lord, paragraph 12.
Yes.
On considering the issue at hand, we are of the view that as the constitution of the selection committee, which had initially considered the research papers of the parties, is different from the committee for re-verification of research papers constituted on a subsequent date, the BTC authorities should produce all the records pertaining to the research papers submitted by the parties herein, which are to be published in peer-reviewed or UGC listed journal on the next date. Then, my lord, your lordship has also observed this paragraph 14. It is also noticed that page 465 that the signature of the chairman of the committee for re-verification is absent. My instruction on this point is that, my lord, when the affidavit was filed, it was hurriedly filed, and therefore they did not get the original. Original may be directed to be produced by the, my lord, authorities. Maybe they may have, my lord. And the, my lord, second direction is, my lord, paragraph 15. List this matter on 5/12/2025, on which they, the learned counsel for the UGC, shall give the clarification as to which of the parties' research papers qualifies with regard to the UGC care listed journals. Therefore, my lord, your lordship primarily wanted to peruse the records and to, my lord, find out how the assessment was made. On that, my lord, if your lordship permits me, I'd like to, my lord, make a short submission. In fact, I myself wanted to know how they find out whether a particular article is published in a peer-reviewed journal or not, my lord. Then I found that, my lord, there are many fake, my lord, websites where it's a scandal, my lord, all over the world, not only in India, my lord. And therefore, my lord, I tried to search how they find it, my lord. I got some, my lord, information. If your lordship permits me, I'd like to produce, my lord, how one has to find out how whether these are peer reviewed or not. What
about for the other side?
My lord, I'm giving
It's only between you and us.
No, my lord. I got 4 copies. Out of copy. Yes. This is only, my lord. This is how, my lord, I
don't have enough.
Yes, I am sorry, my lord. I'll get some copies.
Huh?
I should have given one.
Should be given, the UGC has to be given.
Copy
Lord, can I just come in? Now, UGC was directed to file an affidavit.
Not exactly.
No, but they have filed their affidavit.
Oh, they have filed an affidavit.
Yes.
We said they said.
Yes, no, please come to page 437, my lord. 437.
Just make another.
According to the UGC's affidavit.
Make another 2 copies for the.
I'm really sorry.
We've got no money. We'll pay from our own pocket.
I'm sorry, my lord.
Millard will kindly come to page 439, Millard.
439.
Yes. In fact, at page 437, this affidavit says, para 8. Please come to 437, Millard.
Yes.
that the limited clarification asked by this honorable court, what is the status of publication of research works or articles published in different journal written by petitioner and respondent? So, my lord, concern of the court was not only regarding our client, the concern of the court was regarding both. Then, my lord will kindly come to paragraph 11, page 439. That in the instant case, both the scholar Pramod Bedhi, that is the appellant, and Dr. Pratibha Paturi have submitted the list of their publication along with the names of their journals. The competent authority at UGC has gone through the list of articles written by both the scholars and would like to place its comments, which are as follows. Now, if your lordships would kindly come to the last, my lord, column, journal status. This journal was removed from UGC approved list on 7/11/77. The old UGC approved list of journal was replaced with UGC care list with effect from 14th of June 2019. Now this journal is not in the UGC care list. So none of the articles of the appellant, my lord, were in the list. Kindly see the whole page. It runs up to, my lord, page 443. Now come to, 1 second. Now please come to, my lord, page 443 regarding our client status. 443. Now, my lord, my case also same. Now, my lord, according to the UGC's affidavit, my lord, none of the journals, either of the petitioner or my client, are in the what they call it UGC care list. Now, what is UGC care list? That they have explained. If your lordship would kindly come to page 438, para 9, my lord. They call it Consortium for Academic and Research Ethics, that is CARE. Before embarking upon the said queries raised by this honorable court, the answering respondent begs to state that a public notice was issued by UGC on 28th of November to announce the establishment of a dedicated body called Consortium for Academic and Research Ethics, shortly called the CARE. So when we say, my lord, CARE, it refers to Consortium for Academic and Research Ethics. Now, my lord, at paragraph 12 at page 446, my lord, UGC refrained from making any comment. Kindly see. That the UGC refrained from making any comment on the research article which are claimed to be published in a peer-reviewed journal because UGC cannot comment on the standard and genuineness of peer-reviewed journal because UGC does not keep any record of such journal which are not in its database. Therefore, it is difficult to comment on originality, standard and genuineness of the research work which are not published in a peer-listed journal. My lord, whether the articles written both by the petitioner or the respondents are in the either peer-reviewed or listed journal, that is an issue, it's a larger issue. And I am not disputing. We'll have to answer it. Both will have to answer it. Let's satisfy yourself. But the question is, my lord, when the writ petition filed the writ petition, what was his case? If your lordship should kindly come.
Why are we going back?
No. I'm just saying, my lord. Lordship will kindly see. End of the day, my lord, he must lay his foundation in this case. Court will not make any roving inquiry. Now, it is only in that context, my lord, I'm trying to submit that. If your lordship should kindly come to page number 97, para 15 of the writ petition filed by the appellant.
Who was the writ petitioner?
He.
I am the writ petitioner, my lord. I am yet to complete, my lord. My lord, friend.
No, you get your turn. I just stood up.
Let him complete.
I'm just, yes.
I'll show
Para
you how
15.
wrong statements have been made.
No, what wrong statement I have made?
I'll show.
Anyway, my lord, he has every right to point out what wrong statements I am making. Page 97, para 15. It is his writ petition. It is not my writ petition. That the petitioner respectfully states that respondent number 8 cannot come within the zone of selection for the post of principal of Goreshwar College in person to the advertisement dated so and so, in as much as she is not qualified to participate in the selection process, as there is lacking of minimum 10 research paper publication as per para 5 of the advertisement on the part of the respondent number 8. Further, the document will show out of 10 research papers, only 6 papers may fulfill UGC regulation and rest 4 does not fulfill UGC regulation as it was not published in peer-reviewed or UGC listed journal as per the provisions of the UGC guidelines. Therefore, her selection is expressly illegal. So the pleaded case of the writ petitioner before this honorable court was in para 15 that out of the 10, in respect of 4, it is not published in either peer-reviewed or any other UGC listed journal. That was his case, Milord. Now, Milord will kindly come to the affidavit of the Milord, Vice Chancellor of the Bodoland University at page number 491. Because the chairman of the selection committee was the Milord Vice Chancellor of the university. Para 15. That the deponent submits that in the absence of records of selection process in the present matter, names of the journal submitted by respondent number 8 has been derived from the list of the publication compiled by UGC in its counter affidavit in the present writ petition. Out of the 10 research publications submitted by respondent number 8, the petitioner disputes 4 research publications as not fulfilling the minimum criteria prescribed by UGC regulation on the ground that these were not published in peer-reviewed or UGC listed journal. So, Milord, the UGC was replying to him, Milord, in para 15 and 16. Now come to page 16. Having made the submission as above, the deponent begs to submit that the following for disputed research publication of respondent number 8 had been published in journals that are peer-reviewed, referred journal and research scores of these publications were allotted in accordance with the criteria prescribed in Appendix 2, Table 2 of the UGC Regulation 18 after due verification. So, my lord, the university came up with a clear-cut case that they have verified in respect of the 4 and it was found to be so. Now, my lord will kindly come to the impugned judgment, one paragraph. Impugned judgment at page number 523. It is not an afterthought, only because of an afterthought that his writ petition was dismissed. No. Please come to me, Lord, page 525, para 21. Now, my lord, para 21 contentions are recorded. Then please come to para 22 at 526. The respondent Bodoland University in their counter affidavit has stated that out of the 10 research publications submitted by respondent number 8, the petitioner in so-and-so has disputed 4 research publications for non-fulfillment of the minimum criteria prescribed by UGC regulation on the ground that these were not published in the peer-reviewed or UGC listed journal. Therefore, university confined its response only to 4 research publications. Paragraph 16 is quoted. Then my lord will kindly come to para 23. Therefore, having regard to the manner in which the post of principal has been processed to be filled up, in accordance with this so-and-so and requirement in terms of the regulation, the dispute raised by the petitioner and WPC cannot be accepted, and it also appears to be an afterthought. The respondent authorities concerned would not have appointed petitioner in so-and-so despite having found him to be in the second position and securing lesser mark than the petitioner, on the ground of that the preference should be given as per clause 10 of the advertisement. Said preference, as already stated earlier, can only be applied in case where all other things are qualitatively and quantitatively equal. So, my lord, these are the factual background. Now, my lord, regarding what is peer review, what is UGC listed journal, my lord, to be honest, yesterday I reached very late, as I told your lordship, my lord. And my junior was supposed to assist me. His uncle met with an heart attack. He's in Nimcare hospital. He had prepared something, could not be given to me. So I would be requesting for some time to make submission on that point, my lord, as to what is the significance of that peer-reviewed or UGC listed journal. Because a point has been raised, therefore I have to answer it also.
You see, the reason that we had called for the record was,
yes,
both of you
yes
had said that we would be able to make up our minds and that you would be agreeable to the fact that we could decide whether it was peer reviewed or whether it
exactly.
under
No, my lord.
So
No,
that
your
is
lordship.
simple.
No, your lordship has recorded in the order, which is actually not correct. Please come to that order, my lord.
Okay.
Para 6 of your lordship's last order.
Yes.
Learned single judge thereafter passed a common judgment and order by holding the issue of preference to be given to a person residing Bitera would only come to play when other things are equal. As respondent number 1 secured marks higher than the appellant in the selection process, the preference clause could not be applied by the state respondent. With regard to the issue raised by appellant that the respondent number 1 did not have the eligibility criteria for participate in the selection process, the learned single judge held that issue raised by the appellant was an afterthought. But this is not only afterthought, because the learned single judge, I have shown, my lord, I referred to his writ petition.
No. Basically, with regard to the journal.
No, my lord. But reading this order, my lord, the impression which I am getting is that your lordships took the view on that day. Of course, it is a tentative view, my lord. His case was rejected.
What is his case?
No. What your lordship has recorded in para 6 last sentence is,
yes,
as if the learned single judge has rejected his case only on the ground that it is an afterthought. No, that is one of the ground. Of course, it is an afterthought. Because my lord, in my writ petition, he never raised this point. Neither the college, nobody raised that point. That that the 10 research publications are not in care listed. Nobody has raised. Even he also did not raise.
And it also appears to be an afterthought.
Yes. So, my lord, lordship has not taken note of the fact yes, that's what I'm saying.
Okay.
Well, so therefore, my humble submission is, I'll be seeking some time because he is already protected by an interim order.
Depending upon how we see it.
No, my lord, but I have to make the submission on that point.
First, let us see. Give everyone time.
Anyway, my lord, the appellant last.
You hear him first.
My lord, appellant last, my lord.
Yes, because then you can submit.
Lordship, I'll appeal for BTC in this matter. Lordship, on the RDF. Resolution was adopted on 6/4/2023, wherein my learned friend client, he obtained 61.05% marks, and my learned friend's client, he came second, my lord.
Yes.
Lordship, and on this writ appeal boils down to only one point, whether the 10 research paper was peer reviewed or not. Since the UGC has not come to a conclusion, they are not within the purview to come to a conclusion. So may I suggest one thing? It should be examined by duly constituted expert body, his research papers as well as mine.
That was the proposal that we had put forth on the last date.
My lord.
But if I remember correctly, everyone had said that this court can do it, and this court can do it with regard to whether the research papers were published in the peer journal.
Yes. Yes, my lord.
So it was because of y'all that we had asked for these original documents. Otherwise, it would be easier if we had a consensus with regard to an independent
Yes, body.
selection.
My question was that I do not have any objection if your lordship, my lord, decides on the. I said that, my lord, but I said that my lord also said that, my lord, an expert committee has already decided, and your lordship may, expert committee has already decided it, my lord.
But committee
My lord.
signs the signature of the chairman.
My lord, that record, that's why I said, my lord, the record will release that.
You 61.05.
So when they, my lord, file the affidavit.
No, but then there is a problem here.
My lord.
The problem is the earlier selection committee got a different finding
Yes.
than the subsequent committee.
Yes.
So now which committee should be the correct committee?
Milord, earlier committee had 3 experts at page 213 of the paper book of the AP. Kindly see page 213, Milord. Milord, why I'm saying so, the petitioner, the appellant was of the view that if he can get away with this preference clause, so he goes. And in fact, that is his case also.
But he put in another issue.
Milord, in my writ petition, he never object to all these things. Please come to page 213, Milord.
Yes.
Kindly see, Milord, one gentleman called Jagat Saurgeri, he is an expert. Then, Milord, next down below, Prosen Doimari is an expert. Then, Milord, Sujit Deka is an expert. There were 3 experts. What is there to disbelieve this, Milord? চিন্তা আছে কিছু না বেসিক্যালি তোমার উপরে ডিপেন্ড করে বলে যেহেতু কই দিছে আগরে থেকে ভিডিও টু পোজ আছে in earlier episode also same stand was taken. Isso é mais do que tem now. So that I'm going to commit this, I thought thing man was so.
তাদের কিন্তু এক্সপার্টমেন্ট কোড লিখছি যাবে না।
It is supporting the UGC.
Okay.
Article directed UGC to provide the status as regards the articles written by the applicant as regards the respondent number 1. This has already been categorized in page number 439 of the memo of appeal. Also, that applicant made a small compilation reading the entire journal status as on the date of the publication. The article written by the applicants and the respondent number 1 were published in a UGC listed journal or not. It is up to 2019, all UGC listed journals.
Here, memo of appeal, 439.
Whether UGC listed journal or not, that is important.
No, but then is there a bar for considering the articles that were written prior to 2019 in the old journal? There's no bar.
There is no bar.
There's no bar.
Whether a journal falls within the UGC listed journal or not,
Does not.
that will be prevalent as on the date of publication. Prior to 2019, UGC listed journal was there. So if an article has been published in a UGC listed journal at the time of publication, it will be
Either in the in that earlier journal or in the subsequent journal.
Yes,
That's
sir.
all.
even if that particular journal has moved from the list as of now, but still it's counted as a UGC listed journal.
Correct.
On the date of publication, it was a UGC listed journal.
Correct.
Lordship, if I may take your lordship to page number 439.
Sure. The last page on 431.
Yes.
439 lordship, para 11, there is a table with regard to the appellate, that is Dr. Pramod Mehta.
Yes.
So this serial number tallies with the serial number that I have mentioned in the compilation that I have just provided.
Okay.
This particular journal was removed from the UGC listed list in 2017. The article was published in 2021. That is why this particular article will not fall within the UGC listed journal article. So in that way, I have mentioned in the table.
No, so what do you mean? You mean the serial number one cannot be counted?
Yes. That does not fall within the UGC listed journal article.
Peer reviewed journal doesn't.
Not peer review is separate.
That is again separate.
Yes,
That's why I said, Milord, we have to make submission on that.
peer review.
So, but then it can, if it falls in either of them.
Yes, it
then
will do.
it
will do.
It will do.
Yes.
So this issue is only with regard to whether it falls within the journal or not.
I have mentioned in the column whether published in UGC listed journal.
So it does not fall within the UGC listed journal, the first item. But you have not made any mention with regard to peer review. That's a difference.
I have mentioned whether published in UGC listed journal.
Okay.
UGC listed. Because
So according to you, 6, 1, 2, 3, 4, 5, the appellant. You said, and I would pay for him.
One out of
1.
in the UGC listed journal.
We have to see now whether whether you have got 9.
Out of the remaining articles which are there for your lordships, it needs to be perused whether it falls on it has been published in a peer reviewed journal or not.
Now, what is a peer review journal?
Peer reviewed journal basically it needs to be seen what is the editorial board. I have been in the editorial board of 1 or 2 peer reviewed journals. What is in a journal, there are few editors, maybe 3, maybe 4. The candidate submits the article. It is sent for review to the different editors of that particular journal. We review it. If any correction is required or any modification is required, it comments and it is resent to the candidate. And thereafter, if it is fit to be published, then it is published. But if a particular candidate
Published where?
in the
Peer review journal.
in the peer review. Now, if this review process is being taken care of, then we can say that it is peer review section. If there is no review
Done.
process, there is no planning or no manner in which a peer
Where there is no review of the article.
by the editorial board, then that journal cannot be called as a peer review.
Okay, so unless if it is reviewed by someone other than the editorial board, then it is not a peer review.
There is always an editorial board in a peer review.
Now, is there some accepted peer reviewed journals and unacceptable peer reviewed journals?
Doctor, that UGC will.
How for a peer reviewed journal to be acceptable, do those editors have to have a certain standard of education or qualification? Or can 6% be a member of the peer reviewed journal because he's got a lot of money and he's going to publish the journal?
Qualification of the editor are also mentioned below. If suppose somebody has done a PhD or master or something, it is generally mentioned along with the name. That shows whether that person has an expertise in the field or not.
Miller. No, Milord, I don't appear for BTC, I appear for the other. No.
In the memo copy, it's at page number 465 in the copy which has been annexed. The chairman has not put his signature.
Here there is.
But here we find one thing, with regard to the article number 1 of edu of the
Patwari.
Yes.
It was found that ensuring quality higher education in rural areas, 18, 3, 5, 2, 3, 4, edu. They say that it's not a UGC care.
Care listed, huh?
But they say ISN number is there.
Ah.
Journal website, no functional website. No, could not be accessed. But when we look into the document,
Yes,
which is on record,
yes,
we find that it is a book.
yes.
Whether still a requirement is there that it should be in the site.
My lord, that is why, my lord, I had made that research on, my lord, how to find out the fake, my lord, the websites. These websites, my lord, as my learned friend from the UGC has already submitted, my lord, there has to be an editorial board who will consider it. That has to be reflected, my lord. If your lordship, anyone goes to the website of that particular, my lord, journal, then, my lord, your lordship will not find anything.
This is an issue of 2018.
My lord.
And it was not that. Print out. But this still seems to be a book. If it is a book, that it's already,
My lord.
whether still a requirement would be there, then it should be.
What
Because
do-
this body seems to have proceeded only on the ground, that there is no function.
Yes, my lord. If there is no functional website, that means they may not have any editorial board, my lord. That is how the, my lord, the fake websites are functioning. I am not saying, my lord, whether the respondent number one has done all this, but you make payment and it is published. So that happens, my lord. But then here, my lord, there has to be a functional, my lord, website, and there, my lord, the director, my lord, editors are to be there. And then your lordship, one can be confirmed whether it
Okay,
has.
this is with regard to the re-verification.
Ah.
Where is the earlier?
My lord, in re-verification, your lordship will notice all this, because your lordship, my lord, put the question rightly, how do we know that whether it is peer reviewed or not? For that, my lord, the expert is a, my lord, is a library, expert in library science. That's why, my lord, in the review, my lord, the committee, there is a, my lord, the professor who is a, of library science.
No, he himself is the principal. He himself is the principal now.
No, Cotton
That's why therefore there is no order.
Cotton College. That
Milord-
the expert
Milord,
committee has
public
been.
is-
The expert committee, that my lord, review committee has been constituted in that manner only, my lord, because these questions perhaps, my lord, will not be able to answer, my lord, how to explain whether it is peer reviewed or not. But the fact remains, my lord, even if it is not in the care listed, my lord, UGC care listed journal, it can still be a, my lord, peer reviewed article. And one point, my lord, we have missed is that, my lord, I have submitted 20 papers, 20 publications. In the, my lord, the record your lordship will find, I have 20 publications, whereas, my lord, the respondent only gave 10 publications. And this, my lord, assessment has been done by the UGC in respect of only 10 papers of mine. Because I have, my lord, 20 publications. And, my lord, the submission of my learned friend that, my lord, none of the papers of the petitioner is, my lord, UGC care listed. UGC itself now says, my lord, there are at least 5 which are care listed. And even if it is not care listed, my lord, UGC care listed, it can be.
says it is not in care list.
Even if it is not in the care list, even then it can be, my lord, peer reviewed.
Now, if it is peer review, then mine is also peer review. And the expert has said I have it.
Whether that.
And who has constituted the subsequent?
Let
No,
us
the
see
question
the terms
is.
of the advertisement. sir.
Oh, dostai
Let us see
lage.
the terms of the advertisement.
No, we're not on that. The issue is now, yes, one thing is, why was the second,
Yes,
Actually,
what
why was the
prompted-
committee?
Yes.
Yes.
My lord, my submission with your lordship is that, my lord, my appointing authority is the director. And the director's affidavit has not been considered by the honorable single judge. At all, my lord.
So what did the director say?
By your lordship in
With
the.
regard to this, with regard to this committee?
Yes, my lord. That is what, my lord, I'd like to point out to your lordship, my lord. The director's affidavit, your lordship will find, is my appointing authority, my lord. They found it prudent.
My lord, this director is a biased director because of the, in spite of the judgment, still that he has only the other day, Lordship has passed their status quo order.
The committee
In spite of the
selection,
fact that his
committee
selection was
itself is
set
biased
aside,
against
he
me.
has been permitted to continue as principal by the same director.
My lord, this is because of the of an interim order of this honorable court.
No,
My lord, your lordship will.
Other day,
No,
but
my lord.
judgment is of which day?
My lord, let me submit, my lord. If he disturbs me every time, my lord, I cannot complain.
Disturbing you, go ahead.
Now, my lord, I have submitted 20 papers. Your lordship will see in the record, my lord, I require only 10. Now here my lord, the assessment has been made in respect of only 10. What about?
Committee has taken 20.
That's why, my lord, and there are two aspects, my lord, about the marks. If your lordship kindly sees the, my lord, UGC guidelines, the affidavit of the, my lord, the BTC Director of Education is at, my lord, is at page 49. I'll thereafter come to, my lord, what is the requirement? Page 459. Affidavit in opposition on behalf of the respondent number 2, 3, and 4. Sworn by the director.
Page 459, yes.
My lord. Your lordship may skip and come to paragraph 12 at page 462.
There.
That as regards the statements made in paragraph 13 of the instant writ petition, the deponent begs to state that it is a matter of record as regards the publication of research papers by the petitioner as well as respondent number 8 in the peer-reviewed and or UGC listed journals, and therefore, in this context, the BTC constituted a committee-wide BTC notification number such and such for re-verification of the research papers.
Why?
My lord, my appointing authority, my lord, they found it prudent, my lord, to reconstitute. And my lord, thereafter a meeting was conducted and accordingly the mind lists were drawn. And my lord, another aspect, my lord.
Just one thing.
My lord.
What was wrong with the first selection committee report?
First selection committee report, my lord, if your lordship see, there is a screening committee first. The screening committee, my lord, gets through it, gives it, my lord, to the, my lord, selection committee. And selection committee does not go into these aspects, my lord.
But there's no justification given by the director as to why the re-verification should be done.
In this affidavit, my lord, that is in paragraph 12 only, my lord, that is what is stated, my lord. Now, if your lordship kindly comes to the, my lord, UGC, my lord, guidelines, because, my lord, there are two parts. If your lordship see clause 5 of the advertisement, there are two parts. My lord.
Okay, as per the first verification made,
My lord.
You had 10 papers as per the advertisement. Yes.
Yes, my lord.
The qualified papers.
Yes.
And the respondent number 1.
Yes.
8 or 1?
That's my one, my lord. Now.
Number 1 also had
Yes.
papers.
Yes.
Both, so you both qualify
We both qualify according to the selection committee.
according to the earlier selection committee.
My lord.
Only as per the re-verification done,
Yes.
she did not qualify.
Here is another aspect, my lord. If your lordship kindly comes to the, my lord, UGC guidelines, put us to page 2. My lord, if your lordship kindly reads clause 5 of the advertisement, your lordship will find, my lord.
Page?
Advertisement, your lordship
54.
is at page 54. Clause 5. A minimum of
And a minimum of 10 research.
10 research publications in peer-reviewed or UGC listed journal. This part is important, my lord, and minimum score of 110 research score as per appendix 2 at table 2. Now, my lord, I'll draw your lordship attention to appendix 2 table 2. That is the assessment done by the, my lord, candidate himself. And if your lordship, my lord, kindly comes to that at page 140. Your lordship will find that table 2 at page 140.
Yes.
This is the methodology for university or college teachers for calculating academic research score. Now, clause 2, publication, research paper, clause 1 is research paper in peer-reviewed or UGC listed journal, 8 for science, 8 papers, for arts, 10 papers. Then clause 2, your lordship will find regarding books. Then so far as the markings are concerned, my lord, this has to be given, these are assessed by the candidate himself. And at page 141, your lordship will find research score for each research paper would be augmented as follows. My lord, 10 publications is fine. Thereafter, my lord, this assessment has to be done. I'll again repeat, my lord, I had 20 papers published. Now, papers in peer review journals without impact factor, there is an impact factor 5 points. It doesn't mean that, my lord, one gets the 10 points. Then paper with impact factor less than 10 points. This is how the marks are given, and these marks are given by the, my lord, candidate himself. Your lordship will find in the records.
Okay, then. So what are you trying to say?
My lord,
That she did not get 110.
my lord, no, she did not get the mark that has been given, my lord, without considering this aspect, my lord. That selection committee record, your lordship will find that, my lord. She could not have secured more marks than me.
Oh, because you had submitted more papers.
I had not only I had, my lord, submitted more papers, but my lord, these calculations have been done on the basis of the peer reviewed, this, my lord, factor. That calculation is done by the candidate themselves, my lord.
Okay. Where is the selection committee report on this research publication?
Yes. That will be on the record, my lord.
No, it's not here in the.
Okay.
It is here. No, it is here.
Page 213 is the Milord.
213. Definitely.
Total marks given, my lord, this summing up.
Milord, the contemporaneous sheets.
Different. Life rank. Individual.
In the application form. In the? Yes, my lord. Regarding the research papers itself, my lord.
Selection committee has to give the marks.
Yes, my lord. That will be there. That should be there, my lord.
You have to have 10 people.
Minimum. I have more.
As per the advertisement, 10. Beyond, above that.
That your lordship will find in the record at table 2, my lord. Whether that has been, my lord, assessed or not. No, 10 is a minimum required, but I have more.
As the government.
Yes. Individual marks. With regard to the parking in the second.
Just see that zero.
Yes.
Down there.
Pratibha, she obtained 0.
Yes, how? This is as per the earlier selection committee.
He has been given 5. Sir, he has 10 papers.
And she.
And she.
Yeah, yes.
He has to get 2. By your calculation, VTC calculation. But the 2 is not given. And they.
And then I would get more, my lord.
The petitioner has not been given, say you take 5. He has, then he has, let's say 5. It should have been given 6. Why is he given 5? And if the respondent given 0, we take it that she does not. If at least 2.
At least 2 papers they have said.
One day. One is 2.
This is by the expert, Milord.
By the earlier selection. Yes.
He was given 5.
So Chaudhary, you can also have a look.
So.
Same case, Chaudhary also. That's 0.
Pramod Medi.
Got 5. Second column.
Research paper.
Pratibha got 0.
0. Non-qualified.
So there can be 2 presumptions given the selection committee and considered the not qualified. If that be so, how can you be given between 5? When you should have been given 10.
But otherwise, the total marks is different, Milord.
One that.
Research
So that
paper.
is one of the.
Yeah, one of the attribute. One of the attribute.
You have been given 0.
Non-application of mine. Non-application of mine is very, my lord, evident.
No, we have to have a clear-cut answer. as well.
Yes.
Why it is not happening?
সেই আমি পাইছো এইটো ক'ৰ পৰা আহিল? এইটো এটা মাৰ্ক পৰা আছে। এইটো আছে মাৰ্ক।
I think best let us form a fresh committee and let them decide.
My lord, that is what I propose, my lord.
That will be clear cut.
My lord, your lordship give me some time, my lord. Let me also discuss with our client. But actually, my handicap is today is that even that one note which we have prepared is not with us.
No, that is all right. But at the end of the day, again, we have got to see all this.
No, my lord, how come then I was selected?
I do not know, but these are the records in front of us.
Let the matter come up on Monday, my lord. Let the matter come up on Monday, my lord. I'll answer everything.
I'll agree to any committee, my lord, that your lordship, maybe a central university, maybe, my lord, whatever, my lord. Let it be again.
Let the matter come up on Monday, my lord. Let me also have the instruction, my lord. Because the requirement is either it is a peer review or a UGC listed journal. Now, if it is in the UGC as a peer review journal, and as it appears from the annexures which you have given, page 207 onwards, and my lord, as against the API of 110, I have much more.
Ideally, my lord, each and every, my lord, expert has to give the same marks, ideally, my lord. Because this is not an interview. Yes, my lord.
My lord.
By all the examiners, 7 of them, as per the first selection committee, they have given you 0. But they should have given you a minimum of at least 2.
2 marks.
As it is, they do a prima facie.
No, I don't understand, my lord, that was only one of the attribute, my lord. That was not the.
Maybe, but one is enough.
No, what I'm saying is, if I do not have minimum 10, then I am not even eligible.
That is all right.
No, my lord. Supposing I do not have either in peer review or care listed, then I am not even eligible to apply. So, my lord, therefore, the issue would be whether first, my lord, before your lordship goes to that stage, your lordship should also be satisfied at least what is the meaning of peer review journal and whether, my lord, I qualify or he qualifies or not. Then lordship will take a final call.
For our general knowledge, yes. But for deciding the issue, I think this
No,
is quite
my lord, what I was trying to say is, once your lordship also get a clear-cut idea of what peer review journal is, then lordship take a final call on Monday or
Your lordship may see the part 2, my lord, in the
let the matter come up on Monday, my lord.
In the
I'll
application.
address your lordship on what is peer review.
In the applications.
What is, where is that advertisement again?
Yes, my lord, page 54.
My lord. Selection was held.
3.
The 18 regulations were not fully quickly.
Then, yes. My lord, advertisement is at page 54.
That was on 1st of January 2023. And the selection was held on 6/4/2023.
Clause number 5, minimum of 10 research publication in peer reviewed or UGC listed journal.
I am on the second part, my lord. In part 2, that your lordship will see from the record, my lord, whether that assessment has been made.
And then minimum of 110 research score, I have got 435.
Whether that has been, my lord, assessed at all or not, or the, my lord, assessment given by the candidate himself is taken into consideration.
Page, my lord. Yes. Publication, books authored which are published by national publisher. Chapter in edited book,
assessment must be paid. Methodology for so.
Milord,
On the evidence produced by people such as copy of publication, extension method, completion certificate issued by the university.
Yes. Ah.
The research papers in peers will reduce or implicit research. It is 10 paper. Now, if it come down, this is the way it will be passed.
research score, Milord.
Research for this is the paper, publications other than research papers.
Yes.
Now, research papers would be something else then.
Yes.
Yes,
Publication would be different, so here it is publication.
yes.
Is it? No, there are 54. Or research publication. No, the research publication. It says other, okay, other than research.
So that modality, my lord, marks at
Milord,
page
as
145.
Lordship has read out, Milord,
No, no,
assessment must be based.
If in that case, why is he given 5?
Ah.
Let us say that this is research and other publications of which you should have, other than that we are reviewing. Now, if you even zero, that too for the post of principle.
Ah.
Whether you, this is something we want to,
Yeah.
whether will you be eligible for that?
No,
Then why is the zero given? How will you be?
exactly, Milord.
Selected as serial.
Exactly, that's what I'm saying. Therefore, Milord, to address your Lordships with clarity, Milord, my junior did prepare something, Milord. He came up also, but it was not paginated properly. So I told him bring it in the morning. Then morning he called up to inform me that this is what had happened, Milord. Actually, I could not go through that aspect, Milord. Because before assisting your Lordships, I myself should know, Milord.
Even if we explain, there's a dichotomy between these two. If both of them, all of them were given 0, it's okay. Yes, but where is the basis? But where is the basis for that 5?
Milord, while making assessment also, there are several factors.
State guidelines.
They, my lord, readily I don't have. I think state government has also come up with that.
Regulation, dispatch, first division, dispatch.
Huh.
No, right now I don't have.
Milord will kindly have the matter on Monday. Milord will come up with everything.
Let us see the new verification, the new re-verification. How did they give them? How did they travel?
Yes, yes.
Re-verification,
Re-verification, my lord, they have annexed it to the affidavit. The director has annexed to the affidavit. And my lord, 465 is the report. Then my lord, details are given in my lord, page 468. 468. 468 is the chart. One is by the my lord, restaurant number 1. The other chart is of the.
I think Lordship is correct, Milord, that state government guidelines contains the everything.
The re-verification in your writ petition?
Yes, my lord, that page 468, my lord. My lord, the chart is at 468. The re-verification report is at 465. And my lord, the affidavit also contains the chart, how the my lord re-verification has been done. And out of these 5 members, my lord, the
marks, no marks. This is by the re-verification. And they are only looking at whether, what is the difference between these two? The re-verification does not give any marks. There's no mark, nothing.
There is no marks, but if your lordship kindly comes to page
It's only a report.
468, if your lordship kindly comes, my lord.
207, my lord. Read appeal.
460 is the chart, my lord.
Yeah.
There, one thing I'd like to bring to your lordship's notice, my lord, the note given below.
Yes.
There is a star, my lord. Star
207,
markings.
my lord.
Yes.
These are the 10 thing.
The journals claim to have published the paper within 3 days of submission. Assuming the journal had been a peer-reviewed one, it would have been nearly impossible to publish the article within 3 days of submission, completing the peer review process that demands careful reading, analysis, and thoughtful critique of the reviewers, and also communicating the same with the author to such a short time frame. This is evident in case of the journals where articles in serial number 2, 3, 8, and 9 are published. Within 3 days, my lord, they publish it. They did not go into the marks because, my lord, whether they fulfill the basic criteria of 10 publications, that was exempt.
$54, my lord. A minimum of 10 research publication in peer-reviewed or UGC listed journal.
And the minimum of
And then
110 research
110
score
research score.
as per Appendix 2, Table 2. So this has also to be verified.
Peer reviewed মানে কি peer হলেও রিভিউ কৰিব লাগিব যেমন দি গ্ৰুপো হ'ব পাৰে
What was the self-access?
434. Yes, page 197, my lord, para 8.
What 34?
At page 197, my lord. That the sixth line that the deponent has got 10 of her research paper published in peer-reviewed or so-and-so, which are clearly mentioned in part B at page 3 and 4 of our application form dated 13/1/23, and those 10 research paper along with cover pages of the journal have been submitted along with the application form, which is mentioned at serial number 20 of the content from page 37 to 155. The cover page of the journal clearly shows whether journal is peer-reviewed or UGC listed and its impact factor. The total research score of the deponent comes to 434.5, and research score from 10 research paper only comes to 170, as 6 of the journals where she published her research papers have impact factor between 5 and 10, which gives 25 points for each of the said article research paper. As such, the deponent fulfills all mandatory eligibility requirement of Regulation 4.1 5A of the UGC Guidelines 2018.
So from the records, your lordship will find whether that is, my lord, self-assessment or that has been done by the, my lord, authorities.
Page 207. It's like publication, but this is. There is no. 10. So she gave more, that's what. You have given more than 10.
Exactly.
No, that, you said 10. That is the what is causing, you said you had given only 10 papers. You had given more.
But those were not.
Yes. Huh.
You don't want those things, but 5 months for those things.
Huh.
They say journal publications or the book publication.
These are all in respect of journals to my mother instruction.
Both.
Both my.
Because if you can come to page, you will set page.
Refers to only journals, Mila.
What's this publication?
Yes.
So you have 10,208
Ah.
and you have, then it come down to research publication book.
Yes.
These are taken.
Huh.
Now, other than this, there is no research publication. So the committee, when it was considering, what did it take into consideration? What was taken?
10. It has to be 10, my lord. I may have 20.
No, no, court is asking what was taken note of.
Oh, yeah.
Let us look at the validity or invalidity, let us look at it. Now, here we have 10. And down below B, the page.
Research publication.
Research publication book, we have 3.
Ah.
There is no other research publication book.
Ah.
Similarly, this is the same form you will give.
Yes.
You have given 50.
Yes.
But whether it is the publication of the journal, the book, which is taken by the committee.
Note of.
For that, giving you 5 and giving 0 to.
That is not clear.
No, but then let's say.
This is for different.
It's only for.
Marks there.
Oh.
State guidelines.
Well, I'm sorry, actually, we should have brought that. To 2018, there is a guideline, Mila. Actually, our pleadings were very thick. Annex of like Diana, huh? Yeah. Well, actually, Milord, because Milord. No, গোটেইখিনি দিলে বহুত মোটা হয়।
Yes.
আমাৰ এফিডেভিট বিলাক নাই দিয়ক, আমি গাঁঠি দিছো। এবাৰখনো এফিডেভিট হৈছে না?
কিবা সেই এডিশনাল এফিডেভিট বিলাক দিয়া
যায়।
Conducted the selection process.
The college, Milord. Goleswar College.
Huh?
Neither board and university.
No, Milord, the selection committee chairman was the vice chancellor of Bologna.
My learned friend.
You are.
468.
Who is it? Was it a woman? What is it? No, I can 468. In page 471, my lord, the details are given, my lord. 471.
471.
My lord, the names and their
Amarjyoti Bormon.
Amarjyoti Bormon, he is the SCS Secretary Education Department, BTC Kokrajhar. Then Dr.
Not an expert. He's an SCS officer.
Then Academic Registrar of the Bodoland University.
The expert.
Boldon Bormon, Assistant Professor, Librarian Information.
What we'll do is we'll fix it on Monday.
Yes.
At 3 o'clock.
Yes.
And but prima facie, we are thinking that we are going to send it
back.
Yes, to a fresh selection committee.
That is my prayer.
So you all can, prima facie, but.
Tentative, Milord.
Yes, tentatively. And so please, you all can also consider.
No, Milord, Lordship will do that. Only thing I was trying to satisfy your Lordship's, Milord. That what would be the impact of one having a peer review? That is required. And secondly, that state government regulation. How much mark, whether Milord even, now as long as I have got 10 peer reviewed, even if it is 0 mark, if it is offset in other component, then my selection will still be good. Supposing, my lord, I don't get a mark on a particular count, that is offset by securing higher marks in other, then naturally, my lord, that will have an impact.
My probably, my lord.
Yes, Ms. Beer, please, why don't you provide us how the marks are provided, are to be
Ah.
provided?
Yes.
Obtain instruction as to how marks are to be provided by the selection committee that most probably will be formed on Monday.
May not be possible because members are from various
No,
places.
no, no, how the state government will do it.
You can have Mr. K.
Yes.
Oh, yeah. Yes, ma'am.
No, that
The
circular.
circular is there, my lord.
Well, actually, that circular is a part of the pleading. Some of the annexures are not there, but we'll get it on Monday.
And you all can think of maybe the members there, impartial members, experts who should be a part of the committee.
Yes.
Let it not be from the Brahmapur Valley, my lord, let it be from Kasar. I don't have any objection regarding the my lord.
What
committee.
if it's-
Any comment.
Let you all think of some name. You all think of some name.
One or two experts from Guwahati University can be nominated.
I don't have any.
Give us a proposal.
Principal,
You give us a
Ashok
proposal.
also,
You give us a proposal. Say at least, how many? Earlier one was 7. Earlier
I
one
think,
was-
Milad, that state government circular specifies everything.
Acha, the
How
number
mark,
of.
which marks should be out, how many
No,
experts.
not that, expert committee, okay. Monday, yeah.
And we'll also have that appendix and that regulation.
expert body.
Screening committee, my lord. My lord.
Different body.
Yes, my lord.
And of expert.
Yeah, supposed to be experts, my lord.
That is there in that. Our states.
Yes,
Circular.
Where
I will get that, my lord.
out of practice.
Diploma.
Lordship will retain the records.
No, you keep it, it's too bulky.
Monday at 3 o'clock, Milad.
On the prayer of the party, list the matter on Monday. Pattern is already there.
The interim has to continue.
Interim order to continue till the next. That's the most important part.
Yes.
It's already partnered, no? Oh, list the matter as partnered on Monday.
Obliged.
Now they're. The mark already. That's because of them. No? Clarification. And for to clarify that.
Only one criminal matter is to do.
Oh,
Your Lordship, may I please your Lordship, may the matter be passed over for time
what is
being.
your name, madam?
Ankita Dev.
Heard Miss Ankita Dev, learned counsel for the appellant, who submits June judgment in order dated 14/8/25, passed in special POCSO case number 7 of 2025 by the special judge Chirang at Kajal Gaon, arising out of Sidley PS case number 03 of 2025, by which the appellant has been convicted under section 6 of the POCSO Act, should be set aside. Issue notice, returnable in 4 weeks. Admit the appeal, call for the TCR, issue notice, returnable in 4 weeks. Ms. B. Buyan, additional PP, appears for the state. The appellant shall serve a soft copy of the appeal to the office of the PP, who shall thereafter forward the same to the OC of the concerned police station for furnishing a copy of the appeal to the respondent number 2. The OC shall thereafter submit a report with regard to the above. List the matter after 4 weeks.
Lordship, like, can this matter?
We'll just see. We'll just. Usually, serious on the other side in these cases. I mean, his clients usually. Yes.
This is an inquiry report, Your Lordship. Even this Jagrata Janani Mohila Samiti, even they were given an opportunity of hearing, Your Lordship. Hearing conclusion is the last page, Your Lordship. It's a public hearing given already to them. And it says that none of the complainants reside within the 75 meters, and there is no valid ground of objection, Your Lordship.
Yeah, we have got to be slightly slow. It's very bad.
Yes, sir.
Bad copy.
If I may read, Your Lordship.
Yes.
Report on public hearing conducted in response to public complaint received against shifting of an IMFL off shop from Silpukuri to Ranigir Azara. With reference to the subject cited above, we have the honor to inform you that a complaint petition was received from the President Secretary of Jagrata Janani Mohila Samiti, Radio Center, Patgaon, Guwahati, so-and-so, on 9/6/2025 at the office of the CDC Jalukbari against shifting of an IMFL off shop, namely Whiskey Gogo, held by Shri Sukmal Sinha, bearing license number so-and-so, from its present site, GNB Silpukuri, Guwahati, to a new site located at rented premises of Mr. Harbilas Kakoti, Ranigate Azara. One more complaint was received on 2/6/25 at the Office of Superintendent of Excise, Kamrup Metro, regarding the same matter from Shri Utpal Kalta and 14 others. The last paragraph, that sir, in response to the above mentioned complaint, both parties were called to participate in a public hearing conducted on 18/5/2025 at 18/6 Office of Superintendent of Excise, Kamrup. On the day of the hearing, 18 people were present. Upon hearing, it was found that none of the complainants reside within the radius of 75 meters of the proposed premises as required under Rule 295(3) of the Assam Excise Rule 2016 for the complainants to be considered. Moreover, there is no valid ground of objection as per the prevalent Assam Excise Rule 2016.
Lordship, may hear my senior, he's on legs, your Lordship, in code 23.
Where is this excise rule?
Yes, Assam Excise Rule.
Oh, we have got. Yeah, it's like bottom.
Page 165, your Lordship. 164, 295. Rule 295. It's at page 164.
In mine it's 171. Anyway.
Objection from local bodies and from following person will be considered. In case of corporation, municipal or town committee areas, the corporation, municipal or town committee of concern to which proposal relates and the neighbors, occupiers and residents of the neighborhood or the premise involved. 2. In the case areas situated in corporation, municipality or town committee areas, the Gaon Panchayat concerned, the owners or occupiers and residents of neighborhood of the premises involved. For the purpose of Rule 289(1), 295(1), 295(2), objections from the owners or occupiers, residents of neighborhood located within the radius of 75 meters of the premises involved shall be considered.
Out here, what is his grievance? Is with regard to 289 or 295?
They are objecting the shifting, stating that it will hamper the environment of the locality, your Lordship.
No, out here the issue is that it is within the mandatory distance under 289. 289 is religious places, education institutions, all this. So where is the report on that?
The first page of the inquiry report, your Lordship. The first page, yes, which I have submitted. Report on location and site covered by the AE Rule 2016. The 6th point, your Lordship.
Yes.
The proposal site for the shifting MIFL off shop is located at the rented premises of so-and-so, Metro District and standing a plot over land of so-and-so. The proposal site of IMFL off shop is 10. There is no any educational, religious institution as well as hospital, dispensary, nursing home within a distance of 150 meters from the proposed site. The proposed site is more than 280 meters away from National Highway. However, Population Certificate 36 is given there, Lordship. There is no.
Mr. Kowar, we thought that you'd be appearing for respondent number 5.
Normally I should. Normally I should.
Normally you would.
That's why her state is a dry state, so she is the best person to it. So let them file it in the form of an affidavit. We'll seek a clarification from the client and then let them file it in the form of an affidavit.
I can give them, they can get the clarification.
Yes. Your Lordship will take it up on 10.
No, this is an issue of fact.
Yes, but still, today your Lordship will not dismiss it. I'll just have a clarification from the petitioner on Wednesday. Your Lordship, I'll just have a comment from my client. Let it be on Wednesday 10. Monday, Tuesday, I'm not there on 10. On Wednesday next.
You talk to him 2 o'clock, we'll do it. We won't. Let us have some.
Let us have some material instructions also. Malad will take it up on Wednesday. Malad Monday, Tuesday, I'm not there. She will argue.
It's completely clear, right? Inquiry was complete. No religious institution. Nothing.
Okay, Monday 3 o'clock. We'll fix that Monday 3 o'clock.
Wednesday, Malad?
No, Monday.
Monday.
No, Monday 3 o'clock. She will argue.
Wednesday, Malad, your Lordship?
No, Monday.
Monday,
where?
Wednesday fast item related people.
Monday 3 o'clock.
But I will not be there on Monday, Tuesday.
What are you going to say beyond this?
Well, whatever be it,
this is a question of fact.
Well, I'll just sit, Malad, because they have engaged me. So, Malad, later I also have that privilege of arguing before your lordship on Wednesday.
Monday.
Monday, I'm not here, my lord. I'll be in
Then
Imphal.
we take it today, take it up today. We take it up to, we take it
Monday,
up at 2 o'clock.
You argue Monday. My friend will be there.
We'll also party. Right. I heard Mr. B.D. Paul, learned senior counsel for the petition, assisted by Ms. Zomontu. M. Also I heard Mr. R.R. Gogoi, learned counsel for the excise department. The petitioner has challenged the action of the respondent authority in permitting the relocation of the respondent number 5. The shop of the white shop of the respondent number 5, which is an IMFL off retail outlet, going in the name of Whiskey Go-Go, from its current location at GNB Road, Silpukri, Guwahati, to a new location at Rani Gate, Azara District, Kamrup bracket Metro, Assam. The petitioner's grievance is that the new premises of the shop of the respondent number 5 is going to be in close proximity to residential colonies, educational institutions, in violation of Rule 289 bracket 1 of the Assam Excise Rules, 2006, which prescribes a mandatory distance for setting up a wine shop from educational institutions, religious places and hospitals, etc. The petitioner thus praised for a direction to set aside and quash the permission granted, if any, shifting of the respondent number 5's wine shop from GNB Road, Silpukri, Guwahati, to Rani Gate, Azara, Rani Road, Revenue Village Church. Next up, Mr. R.R. Gogoi has submitted that an inquiry has been made by the respondent authority and there had been a public meeting with regard to complaints regarding the shifting of the wine shop of the respondent number 5 on June 6, 2025. He submits that after during the hearing, it was found that none of the complainants resided within a radius of 75 meters from the proposed wine shop. And as such, there was no violation of Rule 295 bracket Roman 3 of the Assam Excise Rule 2000. He also submits that the proposed new site of the wine shop of the respondent number 5 is beyond the distance of 150 meters from. He also submits that there is no educational institution, religious institution, or hospital, etc., within a distance of 150 meters from the proposed wine shop in terms of Rule 389 of the Assam Excise Rule 2000. So in this regard, he has submitted an inquiry report issued by inquiry report dated 18/8/2025, issued by the Superintendent of Excise, Kamrup Metro District. The
the checklist for IMFL on/off and C full stop S full stop retail license issued by the Inspector of Excise is issued by the District Commissioner, Kamrup Metropolitan District on 18/8/2025. And the letter dated 27/6/2025 issued by the Inspector of Excise. What is this?
Inspector Excise, Borjhat.
Borjhar
Yes.
to the Superintendent of Excise, Amrut M. Above three letters, the above three documents are made a part of the record and marked as annexure X, Y, and Z respective. Para 6 of Annexure X and the contents of Annexure Z are reproduced here and below as follows. Great. And this will be taken from here to this. Okay. On the prayer of Mr. B.D. Kowar, learned counsel for the petitioner who submit that he would like to obtain instructions from the petitioner, list the matter on Monday at 3 p.m. as parted.
All right, Lordship.
Item 31.
Made, please, Your Lordship. Your Lordship, with regards to the judgment, I have submitted a copy of the judgment, Your Lordship. May I submit with regards to the judgment in our case, Your Lordship? Your Lordship, in the judgment, the encumbered property continued and the encumbrances continued, Your Lordship, when the petitioner purchased it from one person, which were previously sold twice, Your Lordship. And that is the fact which requires, as per the judgment, Your Lordship, as per the order in page number 14, Your Lordship, this is specifically clarified. Point number 28. Security interest is now widened and it also includes any other contract, Your Lordship. Here in our case, in it, Your Lordship, this is as per the judgment. Let me now come to the facts of our case, Your Lordship. Our facts are very simple, Your Lordship. I am a builder. I have a property offered for sale. One person comes to me and asks the price. I say the price is 4 crores. He goes to the bank and the bank allots him an amount based on a property which he has mortgaged a separate property, Your Lordship. That separate property is mortgaged to secure a loan of 4 crores or 3 crores, Your Lordship. I will get the money, complete transaction will happen, only then I will give him the flat or the possession, Your Lordship. The bank has given him of half of the amount which he has asked from the bank. He has given me half of the amount, but our is an agreement for sale. It has not been, a sale deed is not executed, neither a final agreement has come into place, Your Lordship. Now he has defaulted. He has already a mortgage property to that effect for which he has got the loan. Here, the bank has not followed 13.2 and 13.4 and a possession notice is pasted in our premises, Your Lordship. This is the case. That particular loan has a different mortgage property. How are we connected so that our property may come into the purview of possession, Your Lordship? And we do not fall within the definition of secured interest.
There is an agreement to sell.
There is an agreement to sale with the party where bank is not a party, Your Lordship. And neither we know anything with regards to the loan and the agreement which the bank had with the respondent, Your Lordship. This is our case in brief, Your Lordship.
But Mr.
T.L. Oscar, Your Lordship.
T.L. Oscar, learned counsel for the petition to submit that the petitioner had executed an agreement for sale dated 9/2/2024 in favor of one buyer who had taken a loan from which bank?
Bank of Maharashtra, Your Lordship.
The Bank of Maharashtra. By mortgaging another property.
Another property, Your Lordship. That is mentioned, Your Lordship.
34. This is the one. This is the one. Which is the this agreement with that. Full stop. He also submits. The petitions council submits that there is no tripartite agreement between the person who is to buy the property on the petition and the bank. However, the bank has issued a possession letter.
Direct possession letter without going through 13 to anything, Your Lordship. Direct possession under 8.1.
Possession letter under rule 8(1)
Pasted in our department, Your Lordship.
of the SARFAESI rules, Security Interest Enforcement Rules 2002. Without following the procedure required under section 13
Two, Your Lordship, 13.
of the SARFAESI Act 2000.
In the meantime, they have put it for auction. That auction will be stayed, Your Lordship, in the meantime, till the next date, Your Lordship. Because they have put it all, we have found a newspaper cutting. They have not informed us anything. We have found a newspaper cutting, Annexure 5, last page of the writ petition, where they have said that our property is out for auction, Your Lordship, without following any due process of law, Your Lordship.
Where?
Page number 51, Your Lordship, last page of the writ petition. This is a newspaper clipping, and the immediate page before that specifically lists out another two property which were mortgaged. Serial number-
What is the date of the auction?
Auction was supposed to be conducted on 28th of October, Your Lordship, but not conducted as of now, Your Lordship. That may be stayed till the next
We
day.
don't know, we don't know. We don't know. Let us hear. The petitioner's counsel submits that an advertisement had been issued for auction of the property in question on 28/10/2025. However, the same has not been done till then. You give Dusty notice.
Indeed, Your Lordship, just.
Issue notice returnable in a week. In a week. The petitioner shall take steps for service of notice by speed post
Indeed, Your Lordship.
within 2 days.
Indeed.
In addition to the above, he shall also serve notice by way of Dusty service upon the respondent.
Your Lordship, one difficulty is that the other respondents are not in the address and they are not accepting any notice from anybody. So we will not be able to.
They are here. Yeah,
We will.
One is here.
Registered post maybe.
1, 2, 3. Huh?
3, 4, 5. Your Lordship.
So if you get to 1, 2, 3, 4. One and two. Dusty notice on 1 and 2. And serve affidavit of service. List the matter on next Friday.
Deeply obliged. Your Lordship.
Yes.
Lordship, on last occasion, it was for supplying the Dusty service upon respondent number 1, Your Lordship. However, when the GST authorities approached Your Lordship on the said address, the addressee was nowhere to be found, Your Lordship. So they also went to a personal address, Your Lordship, of the proprietor. She was not found there also. Thereafter, Your Lordship, the GST authorities issued a panchnama. So Lordship will need further time now to file the affidavit in opposition along with the panchnama, Your Lordship will annex it.
Affidavit in opposition, affidavit of service.
Yes, Your Lordship.
2011.
I have the Panchnama here with me, your lordships, if you want to have a look.
It's, the entire case is stuck up because these respondents are not traceable in a way.
Yes, your lordship.
Or you have not been able to serve notice upon them, correct?
Yes.
Why don't you serve, newspaper publication?
That can be done, your lordship.
Newspaper publication and then we'll dispose of. Otherwise, unless there is an order, they won't appear. What is, the address is not there. The people are not there, so what is to be done? Even if the issue is forwarded, it is suffice. They cannot hear, so they don't know. There's no point in disclosing, no point in disclosing. Well, you file the news, you file your affidavit better, I think. Then we'll dispose of the entire matter. And you'll have no one against you. And if you still lose, so then you'll have a very bad case. There was this case, no? He asked for a degree of book. That's I couldn't tell. We didn't want to return. It will things. What to do? No, then he filed an appeal. And so, I think the only, he's not running now. Okay, right, Miss
P. Upadhyay, lordship.
P.
Upadhyay.
P. Upadhyay, Senate Counsel for the
Applicant.
appellant, submits that notice could not be served upon the respondent numbers. Respondent number 1.
Yes, your lordship.
As the address could not be traced out. Is it?
Yes, your lordship.
As the address could not be traced out. And there was no one in the,
On the given address, your lordship.
there was no one on the given address.
Yes, your-
And as the new address could not be traced out. New address could not be traced out, and there was no one in the given address.
Her personal address was of the proprietor, your lordship, that was also searched. She
The
was
personal address of the proprietor was also searched, but the
not found there.
proprietor was also not found in the said address. She submits that affidavit in this regard will be filed within
2 weeks, your lordship.
2 weeks for such a short, simple thing. Within a period of 2 weeks. This is the matter after 2 weeks.
Obliged to.
Yes, you can put it in the file, your file.
Item 90.
Well, you are. Huh? No. Now he wants to give the amended cost, you have to amend the cost title for giving the correct address.
My lord,
Issue notice.
that we have done, my lord. My lord, may kindly peruse the office order dated 1/12/25 office note. We have taken steps upon the respondent, my lord.
Okay.
Pursuant to
What is
the-
this IA for?
My lord, the IA was for amendment in the cost title because, my lord, the PS was not included in the address of the respondent, my lord. That PS
Okay, that has been done.
That has been done, then we pursuant to
So
that, we
delay-
have taken
so
steps.
delay.
Delay is there, my lord. Delay for my lord, 74 days, my lord. If my lords would kindly have IA 2396.
No, so what has happened to the notice? Have you issued notice on the new address?
We have taken steps.
We have to wait. Right. As notice have been issued on the new address of the respondent on 11/11/2025. This is the matter. After a week.
My lord, it has returned unserved.
It has returned unserved?
Yes, my lord. My lord, may kindly peruse the office note dated 1/12/25, 1/12, my lords. Pink color flag. Pink color, my lords.
That's the IA.
Pink color flag in the beginning.
No, nothing has arrived. List the matter after a week. Await service report.
Date may kindly be given.
Give it. On next.
My lord, 17, 15 are not there, man.
17.
Obliged.
Lordship, there was delay of 29 days, but the name of counsel for the BTSC has not been shown. Let it come next week showing the name of SCBTC for the response. They are the main because they are the
All
working.
them will dispose it of why this.
Otherwise, two cases has been disposed of, condoning the delay, Lordship.
Yes, you just call them. How does it go? You just call them just now we dispose it. Just for this again and again calling is a wasting of time. Just call them as the BTC. Miss Arvind Bora. B. Buyan. Miss B. Buyan.
Item 21.
You should notice, I think. Mr. Yes, any objection?
Well, objection is there because 699 days that is there, but even all there is no merit in the case. Already that order has been challenged in the writ appeal. Justice was there, page 224 is the order. Already that was withdrawn by the petitioner.
200 and?
Challenging this order, they have already filed an appeal, writ appeal. That was subsequently withdrawn as per the
This appeal has been withdrawn.
Withdrawn
By
them, my lord, by the petitioner, appellant. Again, this is the second appeal actually, my lord.
Second appeal.
If I may please, my lord.
Yes.
If I may please, my lords.
Yes.
My lords, the learned counsel from the opposite side is talking about the order dated 21/11/2024, my lords.
Correct.
In that, my lords, in the second last paragraph, it has been mentioned that it was dismissed as not pressed, my lords. And dismissed as not pressed, my lords, the only problem was when the instructions were sought from the client, he could not apprehend what the repercussions of this order would be. My lords, that's why it was not pressed, my lords. And furthermore, my lords, In the 2023 judgment, which is the impugned order, my lords, it says that the pensionary benefits have to be recalculated and given. But my lords, the state, while implementing that order, has taken the tooth out of the order itself. They have given me pensionary benefits, my lords, it's correct. But they have given me on the rank of the Havaldar, which I was in 2004, my lords. When my lords passed the 2023 order, my lords, in that it was written that for the period of pendency till 2023, it shall be presumed that I was in service. If I was presumed to be in my service, my promotion should also have been considered, my lords. That's my humble prayer.
No pay, my lord.
My lords, because my lords, I have been suffering from financial instability only because of this reason. I could not. There is a delay, my lords. My pensionary benefits, I have been drawing the pensionary benefits on the rank of Havaldar. 15 years I was out of the service, my lords. 15 years I was out of the service.
My lord,
2008.
I was there in the appeal, my lord. My lord, justice is there, my lord. And it was withdrawn actually when court finds that there is no merit in the case. On that occasion, it was withdrawn, my lord. Page 20.
That is why we will ask him to pass the order.
My lord. 226 is the order, my lord. Nothing is there, my lord. No work, no pay. Notionally, he was.
In the third last paragraph, my lords, if my lords may have that order, my lords.
Yes, what cost should be imposed?
I apologize. My lords, I have just come to this court, my lords, because there was a
How
slight.
can you re-agitate that same thing once over again? Once it has
No, my
already
lord.
been,
My lords,
you
I'm
file
putting-
a review there, you go before the apex court, that's a different issue altogether. How can you have a fresh appeal once
My lords,
that challenge
my
was
lords,
not?
my lords, the only reason was this. If we see the third last paragraph, my lords, it says that the appeal was dismissed as not pressed.
How naturally?
Because you
that-
made the submission.
My lords, I completely take the blame as a client, but at that time when instructions were sought, I actually could not have apprehended what the
Can you, how
repercussions would be.
be sitting in a different coordinate bench? That's an order of a other coordinate bench. So this is not a review.
My lords may permit to approach and have the proper relief, my lords. If
You
that
withdraw
may be
it.
permitted.
You withdraw it.
My lords, if my lords
We
will
have to
pass an order.
dismiss, we'll dismiss with cost.
My lords may not impose the cause, just note the submissions and dismisses, my
No.
lords. I
You see, the only way that you're going to get out of this is you can withdraw and you can file a review against that's before the same very bench, which had saying that you did not know what you had stated and what was meant by not done. We cannot decide afresh. Sorry.
I bow down then, my lords. I bow down, my lords.
Then, so we dismiss it with cause.
No, my lords. I request, my lords. I request, my lords. No cost be imposed, my lords.
You're withdrawing.
Yes, my lords.
Okay, right. Mr.
Parth Sarthi, my lords.
Name is not here.
My lords, Wakalatnama was filed in the morning itself, my lords. As the main counsel in the matter.
Okay,
due to some personal
what is your name, Mr.?
Parth Sarthi.
Partha Sarthi.
Yes, my lords.
Partha Sarthi, learned counsel for the appellant, submits that he has filed Wakalatnama on behalf of the appellant this morning. He also
For
prays
appearance.
he may be allowed to withdraw the writ petition.
Withdraw
The-
interlocutory.
Interlocutory application. The Mr.
KK Parasat.
KK Parasat, CGC,
Message.
appears for the respondent. The prayer of the applicant is allowed. The application is dismissed as withdrawn.
Should we say something in the act? Will also consider, it will not, not
No,
raised.
no.
Obliged.
Deeply obliged, my lords.
Item 22.
Notice has come for the first time IA for condemnation of delay. Notices.
Issue notice.
Lordship.
Mr. P.K. Then counsel for the, then senior counsel for the applicant, assisted by Mr. S.K. Chakrabarti, submits that there's a delay of 38 days in filing the appeal. Issue notice returnable in 4 weeks applicant shall take steps for service of notice upon the respondents by speed post within 2 days. List the matter after 4 weeks. I didn't read that. What is it?
What happened is we don't have
There's another new.
And finally, they were yeah, but then the yeah, not covered. But we make a moment that this man has been threatening for time. And the way say that it's isolation. Then what they do is that they ask the notice. How it is it will become compliance to do a specific like would
মানুষকে তো 60 বছর লেগে রাখি বলে সেটআপ করে দিলে হয় এটা বছর আছে কারণ আজকাল বহুত ক্ষেত্রে একটু করছে
Yes.
Yes. My lord, if your lordships would kindly come to the order of the Honorable Court, my lord, at page number 481.
There was delay. That delay was condoned and given the rest of.
Page 481, para 19 and 20. The state has para 19. The state has also not placed before the court the steps they intend to undertake in respect of the writ petitioners if they have apparently served for more than 20 years of service. Taking into consideration the submission made by the learned counsel for the parties, and upon perusal of the pleadings, more particularly impugn order dated 11/4/25, read with the office memorandum dated 16/3/15, this court is not inclined to allow the prayer made in the writ petition for a direction for regularization of the petitioner in terms of the OMZ itself. So, my lord, our prayer for regularization in terms of 16/3/15 was expressly rejected. Then, my lord, will kindly come to para 22. However, since the petitioners were appointed under regulation 3F and they have continued to render services for more than 20 years since their date of initial appointment in the year 2005, and on their services being extended periodically by the state, and also in the absence of any explanation on behalf of the state as to why the cases of the petitioners were allowed to be continued under regulation 3F without any proposal for regularizing their services, petitioners shall not be terminated from their services till such time the department takes a decision in the matter in terms of the relevant rule as well as the provisions of so and so. The respondent department will have to take a call on what steps the department would like to take in respect of the petitioner, keeping in view the long tenure of service that they have rendered. The respondent department will therefore consider the cases of the petitioner and under so and so as regards their continuation in service. Till such time such orders are being passed by the department, the petitioners will continue in their service. My lord, before saying on the legality of this direction, my lord, perhaps what the learned single judge was of the view was, all right, your prayer for regularization we are not accepting, but states should take a call on your continuance in service. Nowadays, my lord, we find in quite some cases supernumerary posts are being created and they are allowed to continue, my lord, till they attain the age of superannuation. Here in this case, our work manager. So another 8 to 10 years of services are left. And once, my lord, one attains the age of superannuation, that course will be demolished. Abolished. And secondly, my lord, medical benefit and etc. are being given. So that was the expectation, my lord. Now, my lord, as regards this regularization, lordship knows the law on regularization has undergone a drastic change recently, my lord. In fact, my lord, I may share one thing, my lord. Yesterday, I was in Supreme Court in court number 13 for a matter where precisely, my lord, the honorable bench was of the view that Uma Devi we cannot understand in the manner we were understanding. It was on the recent series of judgments, my lord. In fact, now Supreme Court has gone to the extent of saying it is exploitative. Now, my lord, that is on the, order. Now, my lord, there was an earlier order where I was directed to be regularized. And that order has attained finality. So it's a very peculiar situation. Now, this order of Lanesh Single Judge was under challenge. During the pendency of the writ appeal, there was some delay. So we filed this writ appeal along with an application for condonation of delay. That notice has not returned. No? Oh, sorry, the delay allowed. Now, this order has been passed, so therefore we have filed this I. So that is how the matter stands. If your lordship would like to see the earlier direction of this honorable court, my lord, earlier direction is at page number 57. Page 57, my lord.
The decision taken by the state. My lord, already, my lord, on 1711, a speaking order has been passed. And my lord, on 1711, a speaking order has been passed. Following, my lord, para 22 of the judgment, and they have been discontinued. As on that, they are not in service. So compliance of the order we have, my lord, done. And it is under challenge before the single bench. And on 1812, it is fixed for. No, speaking order. It's under challenge. It's under challenge before the single judge. Then on 1812, my lord, it is fixed for. Then what is there for that?
No, my lord will kindly come to page 57, my lord. No, my lord. The earlier judgment. In respect of the same subject matter.
Page 57.
Yes. The operative portion, para 17. Earlier, our prayer for regularization was rejected. Then we approached this honorable court. This was the direction. Para 17. Under such circumstances, this court is of the considered view that matter will require fresh consideration in the hands of the government for considering the case of the petitioner for regularization in terms of OM dated 16/3/15. The government will examine the case of the petitioner as also the contention raised before this court that several incumbents who are regularized, who were given the benefit of regularization under the OM dated so-and-so, did not fulfill the criteria, but nevertheless benefit of the regularization was conferred.
No, come to page 59 of this.
59 minutes. I am, Lord.
Yes. The second last line.
Page 59 of the IA, Lord.
Yes.
Issue notice, stay prayer returnable 1812. No, Mila, that I know. That we have said, Mila. So this IA we have filed to bring on record this particular subsequent development. But in the writ appeal, Mila, the substantive issue is to be decided. That issue is notice. In view of the earlier judgment, whether it can be done. The Supreme, I have come up with judgment of the Supreme Court, my lord. এইবার নতুন তো। আমার স্টে রিজেক্ট করেছে না? There's not nothing, there's no 58, no? I.
What are these two writ petitions out it? There's different.
Milord, under that particular OM, Milord.
Various writ petitions.
No, my lord, the earlier separate
Earlier,
petition.
Social Welfare Department, they were regularized. There are two
petitions now joined.
Udoy and Aranam Kesin. There are two persons.
Yes, now joined, my lord, for the appeal.
My lord, what I am finding it very difficult is, my lord, that is an issue which needs to be decided. Lordship knows this order, which I have read at page number 59, that has attained finality. A very peculiar situation, my lord. I brought the judgment, my lord, unless that order.
25.
No, my lord, I will independently, no, my purpose of implemented. That
Why it is not to be before?
no, my lord, earlier view was, despite the fact that there were, no, my lord, even if you don't comply with the requirement of that OM, even then I should be considered. That was the judgment, and that has attained finality.
Whether that also can be applied.
Yes.
That you can give. So that will require a hearing.
It will require a hearing. Absolutely. Yes. Yes.
Whatever is the IA, we will not go into.
So the IA part, my lord, we can take care in the learned single judge's order.
So we can close this IA then.
Only thing, my lord, why I filed this IA is, if your lordship would kindly come to page 58. That is the reason we filed it.
Yes.
Second para, my lord.
Yes.
However, this court, while dismissing the matters, had directed respondent authorities.
Page 58.
Page 58, my lord.
Yes. Yes.
This order passed by the learned single judge. However, this court, while dismissing the matters, had directed respondent authorities to examine their claim, as they had already rendered more than 20 years under the regulation FIAP. Pursuant to this, respondent have issued the impugn order dated so-and-so, wherein it is stated that most sanctioned posts of the Inspector of Drugs are now filled up through regular appointment, and hence there is no administrative requirement to continue or the ad hoc appointment. Therefore, their services were dispensed with. However, the learned senior counsel for the petitioner submitted that against the judgment and order passed in WPC number so-and-so and other writ petition, and intra-court appeal has been preferred, which is pending presently. However, no interim order has been passed staying the judgment order dated so-and-so. So it is in that context.
Where are you reading, however? Or however,
Last
no interim
sentence.
order is-
Last sentence. However, no interim order has been passed staying the judgment and order dated. On that date, my lord, we are in service.
Before the list, here also. There, it can be, this before this. These subsequent developments.
Milord, on the day when we filed the writ appeal, we were in service. And Lordship knows there is a division, the Supreme Court judgment also. When it comes to operating that OM, you cannot discriminate between whom to give and whom not to give. You have given it to others. There is a judgment of Honorable Justice B.R. Gavai and Honorable Justice Jalbni, where this Article 14 point has also been. That's why I said, my lord, recently the trend of Supreme Court has drastically changed.
Yes.
Therefore, my lord, in the writ appeal, that issue is to be decided whether in the fact situation that the dismissal of the writ petition on the ground of that we are not entitled to regulation, that is an aspect which will have to be gone into. Yes.
Okay, right. Therefore, so yes, Mr. Gogoi. I feel for all men. Yes. Heard Mr. K. Chaudhary and Senior Counsel for the appearance. Also assisted by Mr.
M. Ahmed.
M. Ahmed. Mr. B. Gogoi. If you notice, Mr. B. Gogoi appears on behalf of all the respondents.
As additional AG, I am appearing now. One thing, Lordship may record that pursuant to the learned single judge's order, the speaking order has been passed on 17/11/25, discontinuing their service.
No, we won't say anything.
No, in the appeal, at least that submission will be recorded then. But
Provided something is given to me.
Where is that speaking order?
Yes, well, it is part of the IA, my lord. It is at page number 51.
Mr. B. Gogoi submits that this is subsequent to the filing of the appeal.
Appeal, yes.
Subsequent to the filing of the appeal. The order dated 17/11/2025 has been issued by the Commissioner Secretary to the Government of Assam Health and Family Welfare Department, which has been made in consequence to the order dated 28/7/25 passed in WPC 2135/2025 and 2137/2025.
And pursuant to that, we have not handed over charge. Lordship will kindly record that. Only our submission.
Mr. K. Chaudhary submits that. Despite the order dated 17/11/2025, the appellants have not handed over charge.
That's
List the matter when.
my lord, in any case, the other matter is coming up on 18th, single judge. Lordship can have it in New Year, my lord.
When? We were it.
any time, January or February.
We close it?
Yes.
All right. Mr. K. Chaudhary, learned senior counsel, submits that he would not like to press the I in as much as the
Single judge is considering the stay matter. on 18th.
in as much as the single judge is going to consider the prayer for stay on 18th of 2025. Mr. B. Gogoi, Judicial AG appears for the state. The application is dismissed as not pressed. I guess
My lord,
it has not pressed.
my lord, in the morning matter, I've checked up with my friend on the other side. The flight has just arrived, my lord.
Huh?
Flight from Delhi has just now. It will not be possible today, my lord. Let it be on some other day. But in any case, after taking luggage and all, they will take at least 1 hour.
Partnered?
Yes. Yes. Lordship can have it on 9th. my lord. In fact, this morning I had a talk with him. He says that the counsel who comes from Delhi is 9th he can.
So he'll be going back again.
Doesn't matter. my lord.
Look, if he can come before 4:30, we can take it up.
Well, it will not be over. I'll take some time. Lordship knows nowadays is a very difficult situation, my lord. What has happened? They do not have the staff. Even to get the luggage, it takes a lot of time.
Why, what's happening?
Something has happened, my lord. Actually, my lord, Actually, my lord, DGCA has set in some new regulation, which they are, I think, finding it difficult to follow. That is the outcome of that. Not আর কে কইলো?
হ্যাঁ, borders.
দেখো, 1 ঘন্টা কোনে রই থাকি? তাহাঁতৰ মতে নহব নহয় চব।
Very little.
লাগেজ লব, আহিব।
So do you want it for 9th? What?
Lordship, the instructions which I hold is they have landed. So how
They have
much time
landed.
they will take, that is another.
Let us wait. If they can come till 4:30, we'll just see 5 time, then we'll fix another date. Let him at least come since he has come all the way. He needs to show that he's appearing.
No, my lord, going by the experience, we know, my lord, they cannot reach before 1 hour.
Huh?
Before 1 hour, they cannot reach.
Let us see if they don't reach, well and good. We won't do anything if they don't reach.
Then, my lord, we'll take a call at 3:40.
So, yeah, so you see, what the thing is that you want for 9th, correct? You want for.
No, this morning he only indicated that 9 days convenient for them. I am here.
No, we don't know. You might be there also.
No, my lord, 9th I am there. 10th, 11th, 12th I am not there. 9th I am there.
Okay, so we'll see
Huh.
when he comes.
My lord, lordship will take a call at 3:45.
Let us see, let him come. Let us give him time till 4:30.
No, my lord, at times, anyway, my lord. 3:45, lordship will take a call.
Yeah, yes, Mr. Counsel, for the respondent.
Sir.
Whenever he comes, as long as he comes prior to 4:30, he can come here. Okay.
Lordship, I'll just leave you a bit.
May please, Lordship. Is an application for continuation of delay. Delay is 130 days, my lord.
Yes. Who's for the note?
My lord, notice.
Right. Mr. Learned counsel, learned Dictionaries government advocate submits that there is a delay of 130 days in filing the appeal. Issue notice returnable in 4 weeks. Applicant to take steps for service of notice by speed post within
3 days.
3 days. List the matter up to 4 weeks.
Obliged.
25.
Okay, this can be allowed. What is there? Mr.
M. Hendik. M. Hendik.
M. Hendik, learned counsel for the applicant. Appears. The prayer of the applicant to serve notice on the new address after filing an amended cost title. A new address of the respondent, huh? The respondent. After filing the amended cost title is allowed. Application is accordingly disposed.
Dusty service I will take.
You want to serve Dusty also?
My lord.
Okay. In addition to the besides taking steps for service of notice by speed post within 3 days, the applicant is also allowed to serve notice upon the to Dusty service. And file affidavit of service thereafter. This is the matter after 4 weeks. I is accordingly disposed of. Oh, this is the matter you cut. I is accordingly disposed. Then in the main case you write. In the main case, you write in terms of the order dated 5/12/2025, passed in 3913 of 2025, the appellant has been allowed to serve notice upon the respondent wife through speed post and Dusty service. This is the matter on give it therefore. I used to this report.
Item 26.
Yes.
I am for the applicant, my lord. We filed this IML to withdraw the amount deposited by the appellant before the registry, my lord. For the honorable lordship.
We allow?
After lordship has deemed fit necessary.
No, why not? 60 lakhs was the alimony granted.
My lord.
Now 20 lakhs only.
Yes, ma'am.
Dismiss the as a ordinate batsman. No, my lord, I am not on that, my lord. That's the issue. My lord.
Your this degree is from CMG.
CMG. No, my lord, that
Yes,
is
lord.
correct. That is correct, my lord.
So if that is so,
My lord.
without proof, think
Altered, my lord.
how can we take a different, what is wrong with the error in the?
Single bench.
No, my lord, the Muktaram, my lordship knows, my lord, it was a distance mode, my lord. That's the, no, my lord, there is a distinction between the in-campus and off-campus, my lord. In-campus, my lord.
Is it NCCL?
My lord, my lord, that is the position of the law. Not required, my lord.
But then what?
My lord,
The section 15
my lord.
CNCL must have.
No, my lord, that law has been settled by the Supreme Court, my lord. Yes, and no, amendment has no nexus with the, my lord. My lord, I have gone through the amendment, my lord. In the amendment part, my lord, this issue has never been amended, my lord. So, my lord can condone the delay, my lord, on merit, my lord. I try my best to satisfy my lord, my lord.
Okay, start
Today,
now.
my lord, today I seek apology, my lord. I am not fully ready, my lord, to.
But my brother is fully ready.
My lord, because I have to assist my lord, my lord.
No. He is going to assist you. Ask him the problem.
I seek apology for today, my lord. My lord can fix it on any date, my lord, next week, my lord. My lord, that is the.
Come to page 192. Para 11.
My lord. Yes, my lord. Para 11. From the affidavit in opposition filed by the respondent number 4, it becomes apparent that the CMG University fails under the jurisdiction of the NCT, and indisputably this university is not recognized by the ECR of the NCT for conducting the B.Ed program. Lord, and it is the categorical stand of the respondent number 4 that on account of absence of recognition by the ERC of the NCT, the university lacks the authority to offer and conduct the B.Ed program under the provision of the NCT Act 1993. Lord, the Honorable Apex Court, Lord, has categorically held that, Lord, when the university is recognized by the University Grants Commission, so therefore a separate recognition from the NCTE, while the university itself is an examining and conducting body, Lord, it is not required, Lord.
This case you take it.
No, my lord can take it. My lord.
Muktaram.
My lord, that is, my lord can examine this. My lord, may I pray for part third matter to keep this as a part third, my lord? Because, my lord, I am not ready with those judgments which I have just to assist my lord, my lord. My lord, even my petition is dismissed also, my lord. I cannot, my lord, say that, but the at least a consideration, my lord, for the, my lord. My lord, the recruitment process is going on for the, my lord, it is around 50, 56, 57 like this, my lord. No, my lord, for the post of headmasters, my lord, not for the post of principal.
Lordship, for this we don't have any objection for delay of 7 days, but for the writ appeal, Lordship, Muktaram Dekar is applicable in this case, Lordship. Lordship, we have not received a copy of the writ appeal, Lordship. Only the IE.
Copy this one, madam.
Yes.
My lord?
Without the written bill copy, she is ready.
No, my respected friend is very, my lord, has gone through and knows, my lord. My lord, I'm sorry that the copy must have served, otherwise it will not be possible to file, my lord, nowadays. My lord. No, even then writ appeal or copy this show up now. Other filing not possible, even then I'll serve an extra copy, no problem. The case is interesting, that's why. এখানে রিচ করে বললেন এইটো মানে সুপ্ৰিম কোৰ্ট যাবৰ কাৰণে এইটো কৰা মই এইটো ওভাৰকাম কৰিব লাগিব নে? রিসেন্ট জাজমেন্ট একটা দিচ্ছে সিংহানিয়া ইউনিভার্সিটি।
Okay, we will fix it on eight. Let me read it. Today itself. So we will hear it on Monday.
Coming Monday, Milo.
Yes.
Monday, some problem. Wednesday, Milo.
No. We are going to make it part heard.
Oh, no, my lord. I will be pleased, my lord. There is no any such issue because my lordship has already delivered a judgment.
Because it seems that my brother is quite aware of.
My lordship has already delivered a judgment in Govind Sharma's case, my lord.
Okay.
That has been assailed to appeal and my lordship judgment has been upheld, my lord. So now that has not been assailed to Supreme Court also, my lord. That is the settled position, my lord. My lord can fix it on Monday, my lord.
Okay, right.
At least few days for in ICU, my lord. This Monday, my lord.
Right.
My lord.
Mr. A.R. Bhuyan, learned counsel for the applicant submits that there is a delay of 7 days in filing the appeal. Ms. P. Barwa.
R. Barwa, Lordship.
I always mix up between you and your sister.
ডাঙৰ কোন তুমি ডাঙৰ
Ms. R. Barwa, learned counsel for the respondent submits that he has got no objection to the delay being condoned. Accordingly, the delay is condoned. Full stop. Next para. Right. In the IE said, right? On after hearing the counsels at some length, comma, we are of the view that the matter should be the main appeal should be heard. The main appeal should be heard, should be listed on 8th as at 3 p.m. as part heard. Registry to list the appeal, and this is the matter on it.
Oblige, my lord. Copy এটা দিয়ে দিন এটা।
Registry to register the appeal and list the same on it.
Oblige.
Timing at 20. What was that matter? Oh, 20 days. Yes. Who is the BTC council?
Here he is there.
Any objection, madam? Just 28 days. No objection, no? Okay. I heard Mr. B. Chakrabarti, learned counsel for the applicant, to submit that there is a delay of 28 days in filing the appeal. Miss Jay Chutia, appearing on behalf of Miss B. Bhuyan, standing counsel BTC submits that she has got no objection to the delay being condoned. Accordingly, the delay is condoned. The registry to list the appeal. Mr. R. Dhar appears for 9. Anybody else? And A. Das for phone number 1 and 3. So you write, K. Das. So you write, So submit, they've got no objection. In view of the submissions made by the counsel for the parties, the delay is condoned. Registry to list the appeal. You see, if you call it, I will have to in the meantime. Oh, he'll be, then we'll know, na, when he comes. Then we'll.
Here's the development. I filed one IM for impeding party respondent team. Those who are not met, my lord, as per my CPC, my lord. Yesterday I filed, my lord.
No, forget that. What is the issue?
Issue, my lord, is we filed review was there, my only, my lord, is which order was followed and order was passed, my lord. One particular one person filed a case, my lord. And he is, my lord, he at the time, my lord, the date, my lord, 1/1/96, my lord, he was qualified. So Honorable Court directed to pay all the arrears, my lord. It was my initially as per fifth and sixth pay commission, it was directed to, my lord, the fixation only. Then there is the notification for fixing on the fixation, my lord. When there, my friend client came before this Honorable Court, my lord, and court directed not only fix, also direct to pay the arrear, my lord.
Mr. Sakya, what is to be done? Basically, he's saying that only 61 writ petitioners were superintendent of that grade 2. The others at that relevant time, they were not superintendent. They were what? They were
At the time, they overseer, my lord,
Overseer.
subsequently, my lord, they became. And when the earlier order was, which was called, my lord, it was, my lord, this as per the pay commission 1/196, my lord, it was, my lord, the effect was given, my lord.
so the pay scale was to be given for those superintendent grade 2
Those
who were promoted prior to 1/196.
Yes, my lord.
And some of them are promoted subsequent to.
87 somewhere, some places.
So supposing we send it back only for that we again decide only with respect to that how many will be left?
87, my lord.
7. We decide afresh on that.
My lord, already, my lord, the post of overseer has been merged with the superintendent grade
Already,
with effect from 1/196.
that is all right.
My lord.
I'm not on that. No, they don't go back into their post or anything. I'm saying that we decide afresh as to whether those overseers also will be eligible for the pay scale.
Yes, my lord. My lord, my first limited submission before Honorable Court, my lord, which was the earlier order, my lord, passed by Honorable Justice Koteswar Singh, my lord, WBC 1537/2015, my lord. The relevant for page, yes, my lord, page is, my lord, 153, my lord.
153.
And the relevant portion, my lord, this page is 168, my lord. Paragraph 30. This was followed, my lord. So my sums.
168.
Yes, if my lord, the other the writ petitioner, the 87, they also, my lord, they come same status of this said writ petition, my lord. Then, my lord, that only, my lord, that modification is required, my lord.
That issue was also, my lord, decided in a different writ petition. In the case of Ghanshyam
My lord,
Vishwakarma.
that is different, but that is, my lord, they are not.
For the others also it was already decided.
Yes, my lord.
My lord, they are, my lord, they non-diploma holder, my lord. Here they are diploma holder, my lord. So, my lord,
hold as a better person.
Yes, my lord. So, yes, my lord. So, my lord, that was one of fixation subsequently, my lord, from 2006, my lord. This they got benefit, my lord. Here the benefit is direct benefit, my lord. Is
I have given the judgment the other day, my lord, regarding Ghanshyam Vishwakarma, my lord.
But can we go into those issues?
No, my lord, as my friend is raising that point.
Because here. My lord, that they raise, my lord, they may raise in a different petition, my lord. That my lord. Here, my lord, only I this my anxiety is, my lord, when this judgment was followed, my lord, this limited, my lord, to 1/196, the earlier writ petitioner, my lord.
But if it's already a covered matter, why should they re-agitate the issue of right?
It is not covered, my lord. But this judgment was passed, my lord. My lord passed this judgment, my lord, following the WPC number 1537, my lord. So if same status is there, my lord, same petition with the earlier petition, my lord. If they are entitled, they will get, my lord. That observation may be given, my lord. Because this order was passed.
So what if they
my lord, this WPC 1537/2005, my lord, the Chandra Kumar, my lord.
Yes.
And his status and the other 87 status is same, my lord. Then they will entitle, but because your lordship is following this.
And even as per this, so they are which para?
My lord, paragraph 1, the text, my lord.
Paragraph 1, yeah.
By this writ petition, the petitioner, who is a regular overseer, is praying for a direction to the respondents to revise his pay scale 5,000 to 8,000 with effect from 1/1/1996. This is the issue. And the penalty with paragraph law will find at page paragraph 22.
Yes.
For the foregoing reasons and discussion, this court has no alternative except to direct the respondents in the given case to revise the pay scale of the petitioner who is working as regular overseer at the scale of rupees 5,000 to 8,000 per month, with effect from the date of date the overseers with diploma in civil engineering enjoyed the revised pay scale of 5,000 to 8,000 per month as per the recommendation of the Sixth Central Pay Commission, which has been accepted by the Government of India, and also pay the arrears pay allowances within 4
Okay,
months.
so when did this overseer be promoted to the post of superintendent?
So, this in the case of Ghanshyam Vishwakarma,
In this one, he was not promoted.
he was not promoted. He was not promoted.
And
He was a overseer, my lord. As on 96, my lord, he was a overseer and he was claiming the benefit of the 5,000 to 8,000.
Yes, but
He's been given.
my lord,
He has been given.
my lord, no, my lord, my lord, they were,
That was my lord.
my lord, area was given to them, my lord, from 1/1/2006, my lord.
No,
And in this, yes, my lord, yes, my instruction is the my lord.
No, just a minute.
Here, my lord, the area,
Just a minute.
yes,
Pay and pay arrear pay and allowances within 4 months. But from which period?
yes, my lord, this, they were given from 1/1/2006, my lord.
first paragraph, my lord, 1196.
Fixation is there, my lord. Fixation from 1/96, my lord.
Just a minute.
Yes, my lord.
No, they are giving arrears of pay from which period?
From
Where to-
1196 only, my lord, they were paid.
No, my lord, that is,
No, where is the proof?
Paragraph 9, my lord. The respondents file counter affidavit in the present writ petition and only stand in their counter affidavit for denying the revision of pay scale of the petitioner to 5,000 to 8,000 per month on the recommendation of the Sixth Central Pay Commission, which has been accepted by the Government of India, is that the Sixth Central Pay Commission has not recommended the higher pay scale of 5,000 to 8,000 to non-diploma holders superintendent grade 2 and super overseer respectively with effect from 1196, and also the recommendation of the Sixth Central Pay Commission for revision of pay scale to the post of overseer of 5,000 to 8,000 per month does not base any right to the petitioner beyond the scope of recommendation of Sixth Central Pay Commission, which has been accepted by the Government of India enacting the rules. It was the stand of the respondents, my lord.
my lord, before that,
You see, Mr. Counsel, another thing, please look at para 19, page 164.
164 of,
Review paper.
160.
Para 19,
19, my lord.
please read.
I'm reading, my lord. Yes, it may be also mentioned while making the state recommendation in respect of superintendent grade 2, 6 pay commission never advised the government to implement the retrospective effect from 1/1/96 for purpose of fixation of pay only. Pay only. In other words, court would also hold the recommendation of commission of government to implement the revised pay retrospective from 1/1/96 for the purpose of fixation pay scale was in respect of the post of overseer, which was merged with the post of superintendent grade 2, and no such recommendation was made in respect of post of superintendent, which the petitioner was already appointed in the 1994 above. Therefore, this court would hold that even the department would be entitled to take a decision to grant a benefit of revised bill 1/96 for purpose of fixation only. The grant of actual benefit from 2006 can be only in respect of those person who are holding overseas post will be merged with the superintendent in terms of Sixth Pay Commission. So, my lord, it is 1/1/2006, my lord.
No.
Yes, my lord.
What are you
My-
reading? How are you reading? It can be only in respect of.
Therefore, this court would hold that even if the department would entitled to take a decision to grant benefit of pay revision of pay of 1/96 for purpose of fixation pay only, and to grant actual benefit from 1/1/2000 to 2006. It can be only respect of those who holding the post of officer whose post will be merged with the get superintendent grade 2 in terms of recommendation of 6. Limitation of qualification, however, will not be applicable in respect of those incumbent like to petitioner who already holding the post so and so so and so. Accordingly, court would hold the decision taken by the department as contained in letter dated so and so cannot be applicable in respect of petitioner who already holding post of superintendent, and had he been holding post of officer.
Yes,
perhaps-
Mrs. Sakia,
Well,
para 19.
yes, my lord. But in Ghanshyam Vishwakarma, my lord, in respect of my lord, overseers also, that issue was
From which
decided.
date? Because as per this, the benefit you have to get from 1/1/2006.
Yes. But my lord, in Ghanshyam Vishwakarma, though it is not mentioned in the penultimate paragraph, but in the first paragraph itself.
No, so what I'm trying to say, you see, this decision regarding your benefit has been made on the basis of this judgment by Justice Koteshwar,
My lord.
not by just the judgment made in Vishwakarma.
Yes, my lord.
This has no role to play.
That is true. That is true. My lord, but review perhaps, my lord, not permissible in this case because of the technical grounds also, my lord, which I have taken on the other day, my lord.
He has filed an application.
My lord, at this stage, whether he will be allowed to improve his case at the time.
No, that's not on the subject matter. It's not on the issue. It's just an addition of the parties.
Yes,
That is the point I have raised.
So what? They can always correct it. It's a curable defect. It is not which goes to the deep into the subject matter in it. These are all technical issues only. Technical cases. His basic case is that the judgment on the basis of which the order has been issued pertains only to the superintendent grade 2. Doesn't pertain to
Yes, ma'am.
overseers.
That is his case.
Yeah. And that is seems to be correct.
And my lord, and in this Ghanshyam cases, we already paid, my lord, from 2001 to 2006, my lord. And here also 61 we already paid, my lord.
And we will say that whoever is
Yes, my lord.
entitled
As per said judgment, my lord.
Huh?
As per the earlier judgment, my lord, which is
for this judgment and as per this judgment should also be paid.
yes, sir. Yes. That much, my
What
lord.
else can be done?
My friend also knows, my lord, this thing, my lord.
Nothing else can be done.
Yes, ma'am.
Otherwise, you have to go to appeal. Right. Acha, your IA filed today.
Yes, my lord.
Is it
That is
filed
what
today?
It is, my lord.
Not on the board.
My lord, not on the court, but
We can call for it.
yes, my lord. There's filing
Give
number.
me a copy.
Filing number is there, my lord.
You call for this. Tell them to register. You call for this filing number IAC 15650/2025. Oh, let it be listed today. Right.
My lord, in the appeal declared against the judgment of Honorable Justice Koteshwar Singh, my lord, Ghanshyam Vishwakarma has been relied on.
Has been relied.
Yes,
Okay.
in the appeal.
Acha.
In the parent. In the parent.
It is there in the record also, my lord. Other day I'm
Okay. Unless you keep on telling us, we don't know.
I marked the paragraph first page, my lord.
In the parent. In the parent.
Appeal.
Correct. That's why having this case again and again, following me everywhere. Yeah, however, the actual benefits
Yes, my lord.
were to accrue only with effect from 1/1/2000.
Yes, my lord, it is there. Same thing, my lord, nothing.
Anyway, let us see. No, corresponding. Just tell me one thing. When was the post amalgamated, merged?
With effect from 196.
196.
Then 1196 is eligible. On that day, he becomes superintendent grade 2.
My lord, lordship may pay, there is the annex,
But
the
here,
F.
superintendent
F,
grade two and grade one, all the three posts were merged, my lord, by letter notification. But given, effect was given on
Annex-
196.
Annexer F, your,
Right.
Annexer F, my lord.
You are all diploma holders.
All
in
diploma holders,
engineering.
madam. All diploma holders, madam.
But Annexer F, some people are there, some person are there appointed 2020, 2000, 2001, 2002, my lord. So, my lord, how?
Yeah.
Yes.
They are appointed.
Yes, my lord, that is I've given the Annexer F, my lord.
Okay, some person.
State, my lord,
They will be getting it from the day they are appointed.
Yes.
They've been appointed.
And my lord,
For those overseers who were there on 1/1/96, they will automatically get the benefits of the 5th and 6th pay commission From 1196 because their posts are merged with amalgamated and merged.
So my humble submission before this honorable and my lord is those who are my lord Chandrakant that the writ petition same status my lord, they will entitle my lord. That observation if there is my lord then because
This is not a question of review. It's only for those for similarly situated persons only.
yes, my lord, I have given the short annexure F my lord.
Right.
Annexure F my lord. So some people, some of the 2011 also my lord appointed my lord.
Anyway, okay, right. Mr. SK, heard Mr. SK Medi, learned counsel for the review petitioners. Also heard Mr. I.H. Saikya for the writ petitioners.
For the writ petitioners.
The learned counsel for the review petitioner submits that the impugned order dated 23/11/2021 passed in WPC 6603/2024, which has been decided in line with the judgment and order dated 18/2/2020 passed in WPC 1537/2015, GS Chandra Kumar was Union of India and 5 others, page 150, huh? And the subsequent judgment and order dated 24/9/21 passed by the division bench of this court in WA number 104/2020. Invert commas Union of India and 5 others versus C. Chandra Kumar. Should be reviewed. First off, he submits that the review is necessary inasmuch as all the writ petitioners in WPC 6603 of 2014 were not similarly situated with the writ petitioners in WPC 1537 of 2015. He submits that out of the 148 writ petitioners in WPC 6603 of 2024, only 61 writ petitioners were holding the post of Superintendent BR grade dash Roman 2, as on 1/1/96. Therefore, in terms of the judgment passed in WPC 1537 of 2015 and the judgment and order dated 24/9/2021 passed by the division bench in WA 104/2020. Only 61 writ petitioners in WPC 6603/2024 could avail the decision, could avail the benefits provided in terms of the recommendation of the 5th and 6th CPC. Full stop. Next para. The petitioner's counsel submits that the review petitioner's counsel submits that the remaining 87 writ petitioners WPC 6603/2024 were overseers, and as such, overseers who had been appointed on different dates and years. He submits that the benefits provided in WPC 6603/2024 can only be given to the overseers depending upon their dates of appointment to the post of Superintendent BR grade 2. Correct?
Yes.
I have Mr. I.H. Saikya, the counsel for the writ petitioner, submits that he has got no no objection or what Means that he has got, huh? He has got no quarrel with the submission made by the council for the review petition. Correct?
My lord, no, but I have raised the technical point, one aspect, my lord.
No, that we are going to allow.
My lord.
That we are going to allow.
The other aspect, my lord, those persons, those overseers, my lord, who were appointed prior to 196, as it was merger.
No, whoever was overseer, who became overseer who were overseers on prior to 1196.
They will be entitled.
They will immediately be entitled due to they becoming superintendent grade 2 on 1196.
My lord, no, superintendent grade 2 overseer, they will merge in
Correct, and
post-
they will be known
as junior engineers.
Acha, they were redesignated junior
My
engineers.
lord.
Correct. Mr. Ayush Shakya, the lead counsel for the writ petitioner, submits that he has got no quarrel with the proposition of the counsel for the review petitioner, in as much as the benefits of the fifth and sixth CPC would accrue on the date of the appointment of the overseers. How can overseers be appointed in 2001 and all when that post is gone?
My lord,
What are you saying?
No, my lord.
1996 it was.
Notification was given later on.
later on, my lord.
Huh?
Merger notification came
Later on,
but
okay.
It was given 196, my lord.
So whoever was okay.
My lord.
Submits that, whatever I said. Of the date of appointment as overseas. Pusta. However, as there was a merger, an amalgamation of the post of overseers
My lord.
and superintendent grade 2,
My lord.
which was redesignated as junior engineer,
With effect from.
with effect from 1/1/1996,
My lord.
those overseers who were redesignated as junior engineers with effect from 1/1/96 would get the benefit in terms of WPC, in terms of the judgment, in terms of the order passed in WPC 6603/2023. Correct?
My lord.
Mr. S.K. Medi also agrees with the submission made by the counsel for the writ petition. You don't agree?
My lord, that in, you may, Lordship may write differently, my lord.
As if you have said that.
No, my lord, they agreed, my lord, sometimes.
Okay, therefore, don't say that.
Department.
I have heard the land counsel for the parties. Mustafa. The next para. The relevant portions of the recommendations made by the 6th CPC is reproduced herein below as follows. Page 160 from here to page 162. Next. The petitioner, the 61 petitioners. Now 61 out of the 148 writ petitioners in WPC 6603 of 2024 were holding the post of superintendent BR grade -Roman. as on 1/1/96. On the other hand, the remaining 87 writ petitioners were holding the post of overseer with a diploma in engineering.
Chemist, some chemist, wasn't it?
Diploma, there's all diploma.
Some the overseer chemist and
Chemical,
the
chemical.
It cannot be chemist
chemical.
or chemistry.
Chemical, my lord.
Chemist.
Chemical.
Anyway, right. So, sir, whatever I said.
Switch to chemical. CHMEC is my charge mechanic. In the cert my friend has prepared that pays my lord 179.
Are you holding the post of diploma?
Yes, madam.
Yes, definitely.
That
they will see.
Yes, my lord, examination.
To stop. In terms of the fifth CPC and in terms of the fifth and sixth CPC, recommendation, comma. The overseers, the diploma overseers. Who are?
My lord, that was to be include the charge mechanic also, my lord.
Why?
Because they also my lord, parts with as junior engineer, my lord.
Okay, but you're not charged, none of them are charged.
There are some charge mechanic, my lord.
Okay, then in the beginning, somewhere, when I have said that, where I have said overseer and superintendent grade 2 merged, amalgamated, is you charge mechanic also. Next, what have I said? Just a minute. Let me see, charge mechanic is there. Again,
179.
No, I want to see the thing. No, charge mechanic is not there.
They are equivalent, my lord.
No, you cut that charge mechanic. It's not there. Sorry. What have I said? The overseers would the post of overseer would have merged with superintendent grade 2 with effect from 1/1/2000, and they would be entitled to the scale of pay of rupees entitled to the scale of pay of rupees 5,000 to 8,000 and all other benefits. It is needless to add that if overseers were appointed subsequent to 1/1/96, comma. So the post of overseers were appointed subsequent to 1/1/96, comma. Their benefits in terms of the fifth and sixth pay commission CPC would only apply from the date of their appointment. Pustak. Accordingly, this court holds that on considering all the above, this court does not find any reason to review the order dated 23/11/2021, passed in WPC 6603/2021, except to clarify the fact that the recommendations of the fifth and sixth CPC would be paid to those overseers as per their dates of appointment, on the basis of their dates of appointment. The only exception being that overseers appointed prior to 1/1/96 would have to be given the same benefit as
The superintendent.
engineers. Superintending B grade 2
We are grade-
engineer. Grade 2 from 1/1/96. The review petitions accordingly dismissed.
Disposed of.
Disposed of.
Obliged. Highly obliged.
Acha, in the main case, in the IA, in the IA, I just right, heard Mr. S.K. Medi, learned counsel for the applicant. Just give me. Learned counsel for the applicant.
This is I found this is.
And what is here? Learned counsel for the applicant who submits that this name, no? That
It starts from my lord. 63 minutes.
No, 60. Huh?
60.
No, where are the persons? Where are those parties?
Parties, my lord, the last portion, my lord.
Huh?
Last paragraph,
Last paragraph?
Page 65, my lord.
Submits this one, huh?
Paragraph 8, my lord.
This one. Okay. One. Could be implemented as
Melody is there, Melody.
respondents number
14.
149, 150 and 151.
Yes, ma'am.
Respectively.
Yes.
As they were respondents in the writ petition.
Yes.
Mr. I.S. Shaikia submits that he has got no objection. Counsel for the writ petitioner submits that he has got no objection to the implement of the
performance.
The above performer respondent. In view of the above, the application is allowed. The applicant shall submit corrected cost title to the registry within 3 days.
Monday, I'll send.
Within 3 days.
Yes,
I is accordingly disposed.
obliged.
Registered in this set. That's all.
First page papers. कहाँ पे करने हैं? दो कॉपी देनी है, 2 कॉपी देनी है। बस एक ही पेज पे सारे में कर सकते हैं। नहीं, जरूरत क्या है, रिक्वायरमेंट क्या है?
Yes.
Yes. Extremely apologize. I had no factors not in my hand. I was in the airport since 6:30 in the evening.
No, it is beyond anybody's control.
I was in the terminal for 17 hours before it took off.
Oh my God.
I was there since 6:30 in the evening. And every 1 hour they would delay it by 1 hour with a guarantee that it's going to fly.
How many people were there in the airport by the time you flew?
My lords, it was a total chaos. Lot of mob. In fact, mob even got into a scuffle with the CISF people. It was a mad house at Terminal 1 in Delhi. Extremely
Yes.
bad. The entire night, it was like that.
No,
And
actually-
finally, they flew off at 12 in the morning. So after 17 hours of waiting, they finally flew. I've been up since 9 a.m. yesterday when I went to court. And then, since then, I've been. But it's unbelievable how mismanaged it is. Not only from Indigo's side, but also from the CISF side. They are not able to even control the crowd to make a queue to come to the information desk. So there are slogans, and you know how mentality is, because when people get together, they start shouting.
Airport must be, the khana and all that must be empty now, all the stalls.
We had to walk through multiple vending machines to find bottles of water by about 3 a.m. Water started vanishing. Water bottles started vanishing. Food, for that matter, the terminal is new, had a lot of options. But it was really very, very mismanaged.
Because of staff.
Well, DGCA came out with a ruling in which they increased their rest time. So what happened? All of the people who were flying out of Delhi, the staff of Indigo, including pilots and crew, were stationed all over the country and were unable to come back because this implementation happened on Friday. And that created a sort of a situation which Indigo wasn't prepared for. And that led to cancellation of 1,200 flights out of their 2,100 flights yesterday. So today, in fact, they have not flown a single aircraft which was scheduled to be flown today. They were clearing out the backlog of 26 flights of last night. And I was, lucky that it happened because only because this matter was parted and I did not want to, leave it in between hanging. I wanted to close it. I said multiple times, he said, let's go back. We can't aimlessly keep sitting here, but we just on the assurance.
Going to go back.
So now, my lords, I was booked on a 8:30 Indigo today, which obviously has cancelled. Then I booked myself on a 5:45 Air India, thinking I may come in time so that I can go back in time. But now I've booked myself on a Air India tomorrow at 1 p.m. And I'll stay back. I have no option.
Tomorrow at 1 p.m.
Absolutely, my lords. Absolutely.
So Air India must be charging quite high now.
My lords, we have booked at about 30,000 a ticket for economy.
Normal ticket.
Normal. Economy ticket, 30,000 rupees.
Anyway, my lord, I think before my learned friend produces the records, my lord, I'll just take 10-15 minutes time.
Excellent.
Milord will kindly come to page 500. The impugned judgment. Para 38. Milord, my endeavor would be to show page 500. Para 38. And my endeavor would be to show, Milord, the learned single judge structured the judgment on a wrong premise. Para 38.
Yes.
On a bare reading of clause 13.1.1 clearly reflects that an eligible candidate, after being interviewed by the screening committee, would appear before the promotion committee for interview. The promotion committee shall, after taking into account the assessment, recommendation of the screening committee, overall merit, suitability, growth potential, length of balance service, qualification, service experience in various functional areas, and seniority of the candidate as the case may be, as may be assessed from performance appraisal record as well as personal interview. Prepare a list of candidates selected for promotion. So far, so good. Next line. Thus, in my view, while seniority would be a factor entitling a candidate to fall in the zone of consideration, but once so empaneled, selection of promotion would be based on merit, as promotion policy shows that it provides for a structured and merit-oriented framework, etc., etc. My lord, my humble submission is the learned single judge, after having, my lord, taken note of the promotion policy, comes to a wrong conclusion that on the strength of seniority, only the zone of consideration would be known. So that is absolutely wrong, my lord. That is not the purport. So it is in that context, lordship will have to see whether the learned single judge properly, my lord, appreciated the promotion policy. In my humble submission, my lord, this very finding shows that there was some mistake in assessing or understanding the purport of the promotion policy. Now, my lord, will kindly come to para 41.
Yes.
Same page, my lord, 501. In course of hearing, having found that equal marks have been awarded to the candidates on seniority from serial number 4 to 17 of the final mark sheet, this court posed a query to the respondent as to how equal mark was awarded to those candidates when petitioner is senior to other candidates at serial number 5 to 17, to which respondents have submitted that equal marks awarded to empanel candidate from serial 4 to 17 in the final promotional mark sheet, the petitioner and his other batchmates from scale 6 cadre stem from the fact that all of them were promoted to scale 6 in the same year. My lord, if seniority is required only for the purpose of determining the zone of consideration, then, my lord, this discussion is, my lord, odious. It doesn't make any sense. Because according to the learned single judge, my lord, seniority in any case has no role. It is merit alone which will determine the selection. So therefore, my humble submission is, my lord, this observation of the learned single judge is also, my lord, flawed.
This is not been given the policy.
No, this is not there. Let me call. Then finally, lordship will kindly come to page 507, para 51. The above case laws relied on by the learned senior counsel for the petitioner, as well as settled principle of law, that principle of seniority cum merit lays greater emphasis on merit and ability, and seniority plays a less significant role. Seniority is to be a given weight only when merit and ability are approximately equal. Thus, in my view, the same would not come to the aid of the petitioner. Now, kindly see, my lord, the dichotomy. On one hand, the learned single judge draws a conclusion on perusal of the promotion policy that seniority is relevant only for purpose of determining the zone. Then learned single judge also tries to discuss, my lord, why the whole batch was given same mark on seniority. Though going by the first inference drawn, that, my lord, consideration has got nothing to do with the instant promotion. And thirdly, my lord,
Yes.
thirdly, my lord, this observation in para 51, it is not really, my lord, I have not been able to find out whether it was in the context of the judgments we placed on merit and merit cum seniority, or my lord, it has got any relevance in deciding the list before the learned single judge. Now, if it was an observation made in the context of the case, then if merit is equal, seniority will play a role. Now, whether my lord, whether learned single judge applied that principle in this case and tried to find out. So, my lord, on the whole, my humble submission is the whole approach of the learned single judge was perhaps, my lord, not correct. Now, my lord, I have already otherwise made my submission. Possible, kindly come to page 108. My learned friend will produce the record, my lord. After that, I'll make my submission. My lord will kindly come to this page, my lord. My lord, this was published on 14th of February. Now, serial number 1, Kalaveni Subaya, she is Mrs. Millard. Now, my lord, she was promoted on 14th of February 2024. My lord, there was a criminal case pending against her. And the final report was submitted only on 19/4, my lord. 19/4/24, the final report was submitted. So how, my lord, a person's case was considered when her conduct in a criminal case was under investigation? The report was given only on 19/4. She got promoted on 14th of February. Then, my lord, this gentleman called at serial number 4, Lalit Kumar Kharbanda, my lord. As I have already shown the other day, my lord, he was responsible for the company incurring about 376 crore. On the contrary, I was instrumental in making profit of 74 crore. I do not know how his merit has been assessed. That is an aspect Lordship will have to see.
said that.
And my lord, when this gentleman, Mr. Kharbanda, he took over, my lord, then his predecessor has made a profit of 13.42 crores. Those are the part of our affidavit, my lord. I'll come to that. So, my lord,
Page
he,
525.
525, my lord, we have given that.
Annexure 2.
Page 525. So, when he took over from his predecessor, that particular office which he headed made a profit of 13.42 crores. But after he took over during the period, my lord, that period which is under consideration in the promotional exercise, he is instrumental for the company incurring a loss of 376 CR. So therefore, it will be very interesting to find from the record as to how his merit has been assessed. Now, my lord, one very important aspect which I am making this, my lord, screening was done by outside experts. And the outside expert has given me 7.6, highest to all the candidates.
Not all the candidates.
Almost all.
7.3.
At least, my lord, more than this serial number 1, 4, 6, and 8.
7.36.
7.65, na?
36.
36.
This was placed in the hearing of the first single judge.
And my lord, my predecessor, when I took over, there was a loss of 13 crore, which I made it to positive, 76 crore profit. Then, my lord, Lordship will also have to see how this
This screening by outside expert is 7.36. How does this play a role here?
Yes, my lord, because profitability is in consideration, my lord, as per the policy. I've read it out on the other day, my lord. I can read it out once again.
Yes, where is that?
Yes. My lord will kindly come to page number.
That's 7.36.
My lord, that I know.
How is it? How is it taken into account? The kind of
Yes, no, Lord, I have given this information because once the records are produced, then Lordship will be able to make an analysis of how things were done, my lord. All that I am saying is, my lord,
Screening committee.
screening committee, there is a 10 mark. As per that page 602, my lord, I have already indicated from my affidavit. Now, screening is done by outside experts. They're not from inside the organization. So they gave me 7.6.
7.36 or 7.6?
36, sorry, 7.36.
And the others, how much did they give?
They got less, my lord. At the instance of the, my lord, outside experts, the other contenders, they got less. I was given more money.
I wonder how this information is available to him.
Sorry, admitted in the learned single.
My lord, my learned friend should read section 123 of the Evidence Act. Then he will not make this answer. My lord, as selection committee proceedings, it is not something which can be withheld from us. For example, my lord, this morning we are doing the case. Lordship has given us copy. We have gone through how the marks was given. What big thing about deal, my lord? Is it something to do with security of the state? Is it a national security detention? If you want to, no, my lord, the section Supreme Court has said, if you want to, yes, you can seek privilege that will not disclose this. Then in that case, my lord, Finance Secretary, Government of India will have to file an affidavit. That is the purport of section 123 Evidence Act. My lord, this law privilege is very clear. Nobody can claim like that. My lord, what is it a document concerning the national security? Is it as a document concerning, my lord, anything?
Let us.
Simple DPC minus, my lord. Some people have been promoted irregularly. We are trying to show that. Why we have referred to this outside expert? Because outside experts are neutral. How I know? I'll show how I know.
On the video. Single just video. $658 video. Sachin service.
Yes.
Now, with the marks you do,
Hmm.
60 for the records.
Yes.
5 or 10 for the senior.
Seniority, my lord, 20, 10. 10.
70.
Ah.
And this 7.6. So you
Interview 20 and 10.
come to the now that's
77.36.
77.36. You can argue that is the marks.
Yes. I'm obliged, my lord. And my lord, I can tell your lordships, this serial number, Sochindra Dattaraman Salvi, he has got less than 60, yet he has been promoted. Lordship will see, my lord, in the interview how it has been adjusted. And my lord, most important fundamental error in this entire promotion exercise is, Lordship knows, normally what is the marks obtained by the candidates in other components is normally not disclosed to the interview board. Normally not done. Now here, my lord, it has been done. Normally, what mark a candidate or an incumbent gets in an interview, it should be disclosed. That my lord ensures transparency. That ensures probity. Now here in this case, my lord, if a person knows that in written or other components he has got 58, he needs 12, then the interviewed member can always give 12. I'm not saying that not everywhere it happens, but there is a possibility. So if as far as possible, this possibility should be obviated. So my lord, I am suggesting these names, my lord. Respondent, this one at serial number 1, serial number 4, serial number 6, and serial number 8. How their cases were considered, that will be very relevant. And my lord, I'll respectfully pray, my lord, after my learned friend produces the record, I should be given a chance to have a look at the sheet so that, my lord, I can make my further argument. Otherwise, this is my argument. My humble argument is very simple, my lord. Promotion policy was not properly appreciated by the learned single judge.
You have not spoken about 8. You have spoken about 6.
8 to KSL, 8 against 6 KSL.
8 marks again.
Karmakar.
It's about the merit. The merit has been less.
My lord, he also got less marks. I think his mark is also less than 60. Serial number 6 and 8. Well, that is our only information because we never had the access. That is somehow I got some information. But that I got 7.36, that I got to know from some source.
No, from the video, single that
He
admitted.
And I'm told, I don't remember. My learned friend, while arguing the matter before the learned single judge, it is seen from the video that he mentioned that.
At 16 point.
And my lord, the records will reveal. So therefore, my submission is very simple, my lord. It's a clear case where the promotion policy as it stands, my lord, was not properly followed. Therefore, it's a clear case where lordships will direct a review DPC. Well, this is how you do not tinker with the right of citizens. My lord. End of the day, everybody has a career prospects in life. My lord. Who doesn't have ambition of climbing the ladder? And with my, my lord, extent of experience and, my lord, contribution to the organization, if I do not get promotion, naturally, my lord, I will be at the disheartened, my lord. I'm not saying I'm not saying that I must be promoted. What I'm saying is, my lord, my case for promotion has not been properly considered. That is my right. I'm not saying that I must be seeking a direction from your lordships. I'm sure, my lord, I have been able to make out a case where lordships have seen the infirmities in the selection process. Therefore, lordships will direct a review DPC to the extent of the infirmities lordship notices in the case. And I reserve my right of reply after my learned friend produces the report.
Where is the mode of marks, the manner of marks to be given?
Yes, my lord. That is nowhere there. And my lord, one more thing, that they have given 2 marks to the interview, seniority component. Where from they got that, my lord?
No, where is the area? Where
Yes.
is
It starts from, my lord.
Marks 8 of this.
Page 862, their rejoinder.
862.
Page 862.
the
Their rejoinder.
Even they have said in the affidavit of opposition, they have said 862.
862, my lord. Work record 60, seniority 10, screening 10, interview 20. It's 62 both bole. अच्छा सर लगभग 608 8 862
मोटा फाइल है
Affidavit of opposition of a patent admit করেছে।
আচ্ছা
Page 862.
Page 862, my lord. Para 44.
Okay, this is the one.
Yes, my lord. And my lord, kindly see the mark matrix. My lord, I think, my lord, the record should also disclose how this matrix was adhered to. Because it's not it can't be a subjective satisfaction of somebody. It has to be because objective criteria are there. Therefore, objectivity must be.
Let us hear.
Yes.
Page 462, in the affidavit, they have said the same.
I'd like to point-wise just respond to whatever my Anand
Yes,
Senior has
sure.
argued today, though I was under the true belief that today the hearing was only kept to see the marks.
Yes.
We had concluded arguments at length, and this is a never-ending process. Each time we meet, my Learned Senior can
We'll try to finish it.
and we can keep responding to that. Now, let's coming to first page 500 of the impugned para 38. I don't know why my Learned Senior only reads the first 3 lines and never reads the last 3 words of that paragraph. That's the only last 3 words is the only thing I want to show, my lords, because time and again a case is trying to be made out today for the first time, never before. Obviously, because this is an observation of the learned single judge, that his interpretation was incorrect, that seniority would entitle a person only to fall in the zone of consideration, and thereafter seniority has no play, is the understanding that is being borne out by the submissions of the appellant here. If my lords may see the last 3 words, while seniority is duly respected. As per the policy 7.1, that consideration has duly been noted and considered by the learned single judge. So therefore, this argument that his understanding or the premise of his understanding of the promotion policy was incorrect, most respectfully, this argument cannot stand in view of the fact that he has in totality considered the policy framework and has noted that in as many words in the impugned order. So we can keep reading 38, but we need to read it in entirety and then that answers it.
Then
Next, my lords, my learned friend has pointed out para 41, page 502.
Yes.
With regards to another interpretation of the single judge where equal marks were awarded to candidates on seniority from 4 to 17 in the final mark sheet, and that a query was posed to the respondent as to how equal marks were awarded. Though I had made brief submissions on this aspect.
What was that page you mentioned that 0.001,
That is clause 11.1 and 11.5 of the promotion policy, which is with regards to seniority marks being given up till the scale of 5 cadre, scale 5 cadre.
No, I'm between the same persons between the same cadre.
Between the same cadre. I'll just point that out too. Let me just open it. That is, my lords, 11.5.2. That is at page 183. Page 183, 11.5.2. That amongst different officers of the same 183 of the writ appeal, 11.5.2 of the promotion policy. Briefly, I had made submissions on this aspect and had also submitted that this aspect was in detail gone into by the learned single judge, wherein this formula of awarding 0.00 marks to the last candidate and 0.01 onwards marks awarded to the each senior, inter se senior candidate, even if applied to this case, would not entitle the appellant to make the cut.
11.5.2.
Towards the end of the page on 183 minutes. In fact, my lords, specifically to answer this query, I had filed an additional affidavit, which my lords will find at page 474.
This is 0.001. 0.00.
Yes, to answer this query of the court before the learned single judge, I had in fact filed an additional affidavit, which starts at page 474 of the writ appeal paper book. And the relevant is at page 481, para 18.
Para 18.
Para 18 at 481. That is the submission that I had extended and is the submission that the learned single judge has accepted and recorded in the impugned order. So I will not read out that again, my lords. Now, after this, my lords, my learned senior pointed out para 51.
Yes.
Again, to show perhaps a flaw in the impugned order. And I would just like to read the first 2 lines of para 51. The above case laws relied on by the learned senior counsel for the petitioner are well set in principle of law that the principle of merit cum seniority lays great emphasis on merit and ability, and seniority plays a less significant role. Seniority is to be given weight only when merit and ability are approximately equal. Thus, in my view, the same would not come to the aid of the petitioners. Now, my lords, if my lords can just come to the previous page at page 506 and see para 50. I will only point out one judgment that the learned senior had relied upon during the arguments before the learned single judge. B.V. Sivaiya's matter. And this judgment is primarily on the concept of a promotion policy where it was based on merit cum seniority. So therefore, the observation of the learned single judge, while dealing with the judgments that were relied upon by the petitioner at that stage, is the observation given in 51 that merit cum seniority's discussion does not come to the aid of the petitioner here, because the policy framework here is aptly clear that merit is the sole criterion as per 7.2, while seniority has to be duly respected as per 7.1. So in my respectful submission, there is absolutely no flaw with the learned single judge's interpretation as far as this aspect goes. Now, my lords, again, the next thing that my learned senior pointed out was page 108 of the paper book, which is the final result of 14th February 2024. My lords, have page 108.
Yes.
And the first submission that was extended was regarding
Serial number
a
one.
certain candidate, serial number 1, who had a FIR at that stage, saying that the closure report was submitted on the 9th of April. That's the submission that's been
2024. Yeah.
2024. For a moment, if my lords can have page 201 of the paper book. While the list was prepared on the 14th of February, my lords, the promotions were effected by way of transfers on the 24th of April 2024. Which is much after the submission of the closure report. This is one submission that I'm trying to make to satisfy this honorable court as to how the pendency of an FIR, which is a mere allegation, my lords, it's not like there was a conviction against that person, has been dealt with and taken care of by the company. Again, my lords, at the cost of repetition, I will have to point out that this aspect of the FIR has been brought on record for the first time as by way of an additional affidavit, only before this honorable court, without craving leave of this court.
This page 201.
Yes, my lords.
What is this? This is
This is the transfer orders
Transfer
post the promotions. So, my lords,
Is there any promotion orders issued?
no, my lords,
No promotion.
no promotion orders. There is only a list prepared, and the transfer orders actually affect the promotions, because only upon transfer does the person assume that charge in scale 7 cadre, which is much after the date of submission of the closure report, even as per my learned senior's submission. Though I do not want to actually rely on this part of this leg of the submission, because I really want to emphasize on the fact that my lords have to completely disregard the aspects with regards to the FIR, the loss, profits. My lords, rules cannot be bent just because it's the convenience of the appellant to file new documents and make out a fresh case at this stage. That broadly answers the points that my learned senior had raised. Now coming to the aspects where what sort of national security this promotion mark sheet holds. This promotion mark sheet has been sought by the petitioner by way of a representation to the company. He has been refused. He came to the court, to the writ court, filed a writ, prayed for these records to be made available to him, never granted.
In which writ petition?
In the writ petition, my lords,
In
that
the
is
earlier. In
the present writ petition, my lords. During the course of arguments, my lords, I can point it out. I'll even point out the prayer clause.
One that has been under challenge.
Prayer kya hai? My lords may have the prayer clause at page 89. My lords have page 89.
Yes.
That's the prayer clause of the writ petition. A is quashing of the notice. B, my lords, mandamus shall not be issued directing the respondents, more particularly respondent number 2, to place on record the parameters under which the officers have been promoted vis-a-vis marks, points allocated to the candidates and the petitioner for evaluation of a fairness in the selection of those in the zone of consideration. Also, the video recording of the interview of all the candidates held on so and so. Sorry. D. Mandamus shall not be issued directing the to place the performance mark sheets of the interview held on 14th February for all the candidates, including the petitioner for the place of scale 7. Specific prayer made before the writ court, post the representation being denied, that these mark sheets should be placed before him. I have made this submission on the last day that he wants to sit as a monitoring committee to try and nitpick issues and try and push his name in the top 16. I'm extremely shocked how he has laid his hands on this list. I think he has a copy of the list right now, which he was referring to. The briefing council was referring to the mark sheet. He has it. Even at the time that this record was given to the learned single judge, the recording is there on YouTube. I had made a specific prayer that this is only for the eyes of the court. I do not have instructions for this copy to be given to the other side. And if so, the court decides then I would like to make submissions of that. The court specifically has said that this is only for the eyes of the court and they will not have access to it. Still, it seems that they have gained access to the entire mark sheet, which I'm sorry, my lords, is not a fair thing. Even today, the prayer is to corroborate everything that he already has and to be able to say more on it. He wants to see the mark sheet after my lords see. My lords had directed me to produce the mark sheet and had also posed a query at me regarding the screening committee, whether they have the APRs and the work records available with them at the time of screening, my lords. I'll answer that first before I go into the mark sheet, my lords. The screening committee is an independent body, ASCI, which is the Administrative Staff College of India. It was appointed in the year 2006 when the policy came about. Policy came about in 2006, my lords. The idea behind getting an independent person to screen the candidates on certain criteria was that there is absolutely no subjectiveness that comes into play because a person who works in the same organization is likely to know the person in some way. So they won out certain parameters at that time. And my lords, I was able to lay hands on the email exchange with the then chairman and director of ASCI to the CEO of GIPSA, accepting the proposal that yes, we will conduct this for you for so and so fee and how we will do it. And on that also these parameters which now find part of the promotion policy in 9.1 have been mentioned. Though it's been mentioned that these are guiding parameters and we will forever keep evolving tools to around these guiding parameters to keep assessing people objective. APARs of the candidates are not available with the screening committee. They only have a one-pager bio data, which to explain it to my lords is akin to the first page of the APAR, which only has the name, age, years of service, current cadre being served at, and so on and so forth. Extremely limited details. Nothing more is shared with the screening committee, which conducts this assessment absolutely basis the modules that they have in fact developed through the years. So, my lords, just to explain, and I took some time to understand this from the company. There are group discussions, then there are group problem-solving activities that are conducted, then there are individual problem-solving activities that are conducted. Then these candidates are placed in different tiers such as supervisory and non-supervisory tiers for different sort of exercises to see and judge how they perform when they are in a supervisory position and when they are not. And so on and so forth, including certain now, because with the help of technology, they've also developed certain tests that they go through. So with all of these modules in place, this is how ASCI conducts the screening exercise. And my lords, this is not only for me or this company. ASCI has been conducting this exercise for various government corporations.
What is the full form of ASCI?
Administrative Staff College of India, Hyderabad. Administrative Staff College of India. In fact, my lords, I have now been told that certain levels of bureaucrats also are now being screened through the same organization, because this is considered as an independent organization being used by the government on a regular basis. So as that answers my lord's query. My lords, I have passed on two sets. One is the original certificate and one is a photocopy. My lords will have document number 1. That's the first document. Now, my lords, this is the mark sheet, the final mark sheet by the promotion committee.
We could have made photocopies of this.
Please, my lords. My lords, only for my lords' convenience, I have made it. My lords have said we'll see it and we'll give it back.
Yes, yes, we'll give it
I'll
back.
destroy it.
No, because that kind of photocopy, we can make notes out there. But
So we have a photocopy, my lords.
okay.
If my lords, we have a photocopy. My lords, document number 1. My lords will see report of promotion exercise scale 7 24-25, report of interview cum promotion committee. And then my lords will see that in terms of para 13.1.1 of the promotion policy, so and so people form the promotion committee. Now, lords, please see serial number 7. The joint secretary, DFS, Ministry of Finance is also part.
Yes. Sure.
Now, my lords will see the under the first numbered Roman paragraph, second unnumbered para, because this query had fell from my lords. 48 eligible candidates of 47. There were total number of 16 vacancies. 48 eligible officers were impaneled in the zone of consideration. But Mr. So-and-so did not attend the screening exercise.
Okay.
And therefore, a total number of 47 were screened. Now, my lords, the weightage of marks that has been reproduced by my learned friend, and so have I, is towards the end of the page. Work record is 60 marks. External assessment is 10 marks, which is the screening committee. Seniority is 10 marks. Interview is 20 marks. Total comes to 100 marks. Now, my lords, these are the enclosures. I'll take my lords through the enclosures. On the page 2, all of the enclosures are written. They have thoroughly examined the annual performance appraisal reports of the candidates of the 6 years. In terms of length of service, they have awarded marks to such seniority. They have conducted interview. 4, they have assessed the personality and other requisite traits of the candidates and awarded marks for interview as per enclosure 2. And as after taking into account overall merit, suitability, growth potential, length of balance service, exactly as per the promotion policy, it's mentioned in para 5. They arrive at the list in enclosure 3 minutes. Now, the list that my lords will see on page number 2 is the final list. My lords may not see this. We'll go to the mark sheet straight away. Enclosure 1 is at page 4.
Yes.
Again, the weightage of marks on the top of the page, and the breakup of the marks given towards work records. That is para A. Award of marks for work record as per evaluation of ACRs. So what is the further breakdown, which totals up to 100, and that 100 is then compressed to 60 to form 60% of the total marks. Now, my lords, we'll see B, which seems to be the bone of contention here.
Yes.
Which is seniority in terms of length of service.
Yes.
Now, my lords, in this particular batch of zone of consideration, we had people from the batch of 22-23, which are the junior most people. So 22-23 gets 0 marks. Now, we'll see the corresponding column. For batch 22-23, they get nil marks. 21-22, which is the next senior batch, gets 2 marks. 20-21, the next senior batch gets 4 marks. And 19-20, which is the senior most batch of the people falling under the ZOC, gets 6 marks.
And petitioner
is 21-22.
Yes.
Now, my lords, will see enclosure 2 is only the interview marks, but we can straight away skip to enclosure 3 at page 7, my lords, because that is the final score which includes the interview marks as well. Enclosure 3, my lords, may have.
Yes.
At page 7. Now, my lords, will see the columns. On the right side, CR is work record.
Yes.
SCN is screening committee.
Just a minute. CR is
work record.
SCN
is screening committee. The third column, SEN dot, is the seniority. Fourth is interview. And fifth is the total ones. And my lords, for my lords' convenience, if my lords can just see the last page of the compilation that I've given you. Instead of seeing this mark sheet in this manner, the last page is the compiled mark sheet as per the descending order, which I've prepared for ease of reference. Here they have been
Just let me get back.
Please, my lords.
Where is the list of persons that
108 million.
108.
Serial number 4, 6, and 8.
Now, my lords, may I?
Just a minute.
Please. $84.96. 84.96. Calculate. कोई बात नहीं, कोई बात नहीं. 6 minus 81.23.
Okay. Yes.
Lords, may I?
Just a minute. Just let me see this petitioner.
He's at 19 minutes. 19. My lords, have the last page of the compilation I gave you. Was document 3.
Yes,
That's-
I've got that.
yeah, in that, my lords will find him at
I've noticed.
19. Now, my lords, in this list, in the document number 3,
Yes.
my lords will notice the highest mark
Yes.
of serial number 1. In fact, serial number 1 is the same lady against which the FIR is being alleged. But she is also the senior most, which is why in the seniority column, she is scoring 6 marks. That is 4 more than the appellant herein, because he falls in the batch, 2 batches junior to him.
Yes.
Now, my lords, what I want to point out is that the competition is so cutthroat that the difference between the total marks obtained by serial number 1 and serial number 16 is 3.73. It is not as if there is a big variation of 10 marks, 12 marks, or a big band available. So people are making the cut by point some marks. So if the total difference between number 1 and number 16 is 3.73, and if the appellant, just by way of being the third junior most batch being considered, is falling short of 4 marks in a uniform manner with no biasness, in my most respectful submission, we don't even have to go into the other aspects. And on the contrary, if my lords will see, serial number 4, 15 and 16
Yes.
have scored less marks as the junior, as the appellant, as far as the work record is concerned, but still fare well on the other aspects. So, when these candidates have been assessed on parameters which are absolutely laid out in the promotion policy, to now come to subjectively start pointing fingers that why has this been done in this manner and why has this not been done? These fingers were never pointed when the appellant came from scale 5 to scale 6. There also, multiple people did not make the cut. The entirely same marking system under the same policy framework was followed. Some lords had not asked me for the screening committee's marks, but I got those as well, which are the landscape mark sheet, my lords. That is the further division of the screening committee marks. My lords had only in the order directed me to get the final mark sheet, but I still got the screening committee marks as well to show on various parameters how the screening committee has marked each one of us. Now, let's for a moment in that list, document 3. May I have the last page of the compilation notes? Document 3. And may I please mark serial number 17.
Yes.
Now, serial number 17 is somebody who's from the 2020-21 batch. Even one batch senior to the appellant herein. doesn't make it, even though he gets 2 extra points for seniority. But doesn't mean that something wrong has been done with him. There are different aspects of this promotion exercise. They all come together to kind of consolidate the final mark sheet and the final list which gets approved for promotion. The learned single judge most respectfully has not only seen these documents but has seen the entire record, voluminous record of the entire promotion exercise, including APRs of last 6 years of each candidate, and has come to the conclusion that the policy has been followed. So in my respectful submission, if the policy has been followed, and with the submission that my learned senior has made very emphatically on the last date, that I am not challenging the policy, I want the promotion under the same policy.
Of course.
So if the policy has been followed, my lords, most respectfully, there is absolutely no reason for any intervention with the learned single judge. That said, my lords, of course, it will be my respectful submission and prayer that these documents may not be shared with the petitioner or with the appellant, which I do now presume that he already has access to.
Probably.
Well, I'm also passing on. Just one
Sorry,
second.
yes, please.
I'm also passing on a copy of my written submissions. Sir,
Thank you.
2 originals.
So there's a screening committee and there's a selection committee or a promotion committee. What's it?
There's a screening committee and there's an interview cum promotion committee.
Interview come from.
So interview cum promotion committee constitutes all of the chairman cum managing directors of all of the insurance companies, plus the joint secretary of DFS MOF. And screening committee, of course, my lord, is ASCI, the
পাঁচটা বাজে বা ওর দেরি হয় কম্পাউন্ডার 6টা বাজে 16.38 মিনিট প্রিয়ঙ্কা কিরকম ভিডিওটা 16.38 মিনিট না তাতে কোয়া 7.36 and minutes आपने खुद ने बोला था मैंने
अच्छा अच्छी बात है जो रिकॉर्डेड है उसको आइकन देना है
कहाँ तो फिर ये उसको मटेरियल नहीं कोई नहीं
सॉरी आपका लेट
बहुत देरी हो गया भाई इसलिए घर में कुछ काम भी था फोन कर दिया दिन का उपाय भी नहीं है ना My lord, I think my learned friend has concluded to 1 minute. My lord, my learned friend has said that my prayer was there in the writ petition, it has been denied.
Correct.
But nevertheless, I'm on appeal, my lord. I don't think I will give further answer to that. I'm on appeal, number 1. And number 2, my lord, that I got maximum 60, that I got 7.36. This was an argument which my learned friend himself made before the single judge. We're having the video also. If necessary, that can be shown. So we never had any access to any record. Now, my lord, if your lordship is satisfied after going to the records, I have got nothing to say. But lordship will definitely take note of 2 aspects, my lord, which I've already said. Yesterday, day before yesterday, I said, my lord, interview was for only 6 minutes. But the screening committee took for 2 days, my lord. 6 minutes. And lordship must have seen how, my lord, it was somewhere where it is shortcoming, he is made up. This must have happened because they themselves plead in their affidavit that promotion at the higher level is subjective. That page 251 I have already placed that, my lord. They themselves, it's not my case. Let us not shy away from that. It is their, my lord, own pleaded affidavit. Control page 2. 1 second, my lord. Affidavit, yes, serial number P. If your lordship should kindly come to page 231, my lord. And they candidly say so, page 231. It is submitted that promotion at such higher level are subject. It's their case, it's not my case. So that is the subjectivity must be reflected in the records. And thirdly, my lord, I have already started the case by making an argument that it's not a case where the criteria of merit cum seniority applies. It's a criteria of merit and suitability with due regard to seniority. And on that point, my lord, I have already placed that judgment. What is merit and suitability with due regard to seniority? And single judge, my lord, as I've already said, my lord, has confined seniority only for determining the zone of consideration. And finally, my lord, the fact that same committee interviewed also part of the promotion committee, my lord, that was an error. Because they're not supposed to know what are the other component of the marks. Then in the interview, they may not, it can be inferred, my lord. That's why, my lord, the Witnessbury principle of reasonableness will apply. So, my lord, judicial review is available on 3 counts: illegality, irrationality, and, my lord, procedural impropriety. Here it's a case, my lord, the entire action is irrational. Therefore, it is a case of malice in law. And, my lord, on what basis you are giving 2 marks? What basis you are giving 6 marks? Which part of the promotion policy says so? And please see the heading of clause 13, my lord. They can't rely upon 7.2 per se. The policy has to be read as a whole. Since it is a case of merit and suitability with due regard to seniority, each component has to be respected. But according to the learned single judge, my lord, whose judgment is under challenge in this case, was of the view that seniority is required only for the purpose of determining the zone of consideration. So that view of the matter, my lord, also will take a call in the judgment. That's my humble submission.
Can I only respond to one thing additional that he, just the additional part. In fact, I had point by point only.
Since we have already.
I'm extremely grateful to Manoj to have extended this. I'm so grateful, Manoj. I don't know from where he gets it that 6 minutes was his interview time. But be that as it
appeared in the interview. No, you say it. That's why
I did not interfere, sir.
I also.
So please.
My intention is not to disturb you. Please go ahead. Because I appeared
So the
in the
case that Manoj is trying to be put forth and which was also submitted on the last date was that it was done in such a hodgepodge manner. Manoj, I would see it in another way that within these 6 minutes, we were able to go through last 6-year APRs of everybody. Also decide who we want to promote, who we don't want to promote, calculate everything from the screening committee to rearrange the marks in such a manner. This is an argument in the air. Of course, anybody who does not benefit from a certain promotion exercise is going to point fingers saying that the promotion committee, which is the final committee, did not see it properly. But that can't be tested like this. What needs to be tested by my lords is whether my promotion policy, the framework which is provided for, has been followed in toto or not. Again, at the cost of repetition, no such allegation when he benefits. Only allegation when he does not get promoted. And Manoj, regarding the judgments that my learned friend had referred to, I've already dealt with that in my written submission. So I'll not repeat that. I've given my written submissions today that maybe please be taken on record. Was that the judgment compilation? I have another copy.
No, it'll be.
No, Manoj, I had given 2, but I am carrying 2 more.
No,
in
no.
case.
Huh? Yeah.
Of course it was.
Wait, one is enough. I think this is the one. Yes, we have got this.
Right, Milords.
And
Written submissions I have given today, Milords. Written note of my arguments. As long as it's for the eyes of the court. Milords, can I only make one small request? Once the judgment is pronounced, can I then request my lords to have this back, because otherwise it will go into the record and.
No, I'll tell it.
Oh, fair enough. Fair enough.
Milord,
Fair enough.
Milord,
I am my lords.
this morning, my lord, this morning, Lordship had that matter. Well, Lordship has shown us. That is also a selection of principle.
Out there, there's nothing to show. If
Nothing.
There was,
Milord,
there was something.
Milord, that's why I said, Milord, that's why, Milord, in MP Sugar Mills case, Supreme Court says, when government should be allowed to resign, that satisfaction must be of the court, not of the executive. Now, since your Lordship, MP Sugar Mill, Milord, Justice Bhagavati said, why? That it is the court whose satisfaction is utmost importance, not of the executive.
And therefore, my lords, the learned judge has been amply satisfied after going through the entire record. That's my only submission on this.
+60 7.36 is how much? 77.36.
67.36.
67.36. I don't get, somebody else gets. Beauty, Mila, beautiful.
2 marks. No comments, because everything is.
No, Lordship have to decide, Mila.
Unfortunately, my lords, this is the entire case. Out of 48, 16 had to be promoted. The comparative merit under the policy framework, 16 go through, the others don't. It's as simple as that. Unless there has been a malice, arbitrariness, biasness, then of course, then I can't make any submission. But if the policy has been followed in its total and marks have been awarded, I don't understand how the remaining people who have not been promoted come to court. This will actually open up.
I think my learned friend is exceeding his brief now. He's not even telling when should we come to court. Sorry. My learned friend is now trying to say, no, my lord, there are limits to everything. Learned friend says such litigation should not be entertained. To that extent, he is going.
No, absolutely not. I mean,
how many years have appeared on this side? I have appeared for 20 years. Don't show me.
And I have a lot to learn from you, sir. But
Sir, Delhi wala mixer hai, Nilva wala.
My learned senior tends to get.
Huh? Reserve.
Obliged.
I heard because it's not that we can start dictating, but it'll take too much time.
After all, today is Friday, Milord.
Well, we'll be happy to assist, my lords.
We have got a lot of work together to do.
We would have been very
naturally. Can appreciate those things.
Okay, I heard Mr. K. Chaudhary, learned senior counsel for the appellant, assisted by Mr. S.P. Sharma. Also heard Mr. Zorawar Singh, learned counsel, number 2.
With Mr. Shubham Jain.
With Mr. Shubham Jain.
Shubham Jain.
Also heard Mr. Okay. The hearing concluded, judgment reserved.
Highly obliged, my lords. Extremely apologize to keep my lords.
No, that was not your fault.
Practice were not in my hand.